So we are live on YouTube and we are live on Collaborate. Team, coming to the end. It's nearing the end. And I've just opened up Enrico's image. Sardinia. Oh, interesting. Okay, debt and bankruptcy. What are we going to do? I'm going to kick off and just run through this. We'll just run through the topics. This is actually a shorter lecture. So what I'm going to do, we're going to do this, and I'll talk about the exam at the end, I think. But I think to allay everybody's fears, so you can sort of listen to this stuff without being too worried, I haven't got to doing your assessment. My stage ones have taken much longer than I thought. But I'm aiming to do, probably by the end of this weekend. I'm going to do actually going to do the take-home test first, and then I'll send some feedback about that. I also think we should do an additional session, that's specific, essentially going over the exam stuff after we've got a little bit of feedback from the take-home stuff too. So I am going to talk about the exam a bit tonight, but I think we'll do another session. So it's really up to you guys. And again, hit this up in the chat as to what's a good evening to go and do that, be that Monday or Sunday. It's really up to you guys to thrash out that one there. It doesn't matter. Every day is the same for me. So like Sunday night ideally is probably the better one, but Monday, no, yes. Anybody else?
I'm so sorry. Hi, I just came
Hi,
Monday
Hina.
for what?
Oh, you've got accounting. Okay, there's no 10
Yeah,
minutes.
Sam, we're accounting Sunday.
You've got accounting on Sunday. Okay, sure. All right, so Monday.
Are we
Monday.
having an extra class?
Yeah, we will do. We'll do a specific exam prep session. Usually, what I would do
Okay.
is I'd have 1 week allocated for that, but because this semester's been compressed somehow, and so the exam. Look, I'm going to be blunt with you. I'm just the exam's going to be much easier than it was in previous years. So for those that are in class with Collins and with Emmanuel and Jean and the people that did this subject last year, they're going to be sad because they're going to find out how much easier this exam is going to be. But it is going to be based on stuff towards the end, like weighted towards stuff at the end of the semester. Particularly, it's going to be a chunk of it's going to be from the material from today. Some general knowledge stuff about the banking system, which is what we're going to be talking about. And we're going to have, I'm going to be talking about debt and bankruptcy and the mechanical steps of that. But really important for the purpose of you guys as business professionals, I have included something in here that I haven't even checked if it's in your text, but it's an important, quite short series of rules to do with legal offers. And this is something that, in my mind, is absolutely paramount to strategic management and accounting practice when dealing with legal matters. So we will be talking about the rules for offers that Gaetano and those that did this in the stage run, you definitely wouldn't have had through Neil's subject. So we were going to go about that, the offers and the mechanics for accepting offers, and most importantly, the impact it has on legal costs as part of that process. All right, so that's what we're going to go through and do. So the banking bit's really a little bit more sort of general knowledge-y. And I probably will put some questions in the exam, but they're going to be very, very light. You're going to basically, because this is an MBA level subject, you'll have access to all of the lecture slides, but your answers is going to have to take stuff from the lecture slides. You're going to have to think about it a little bit in order to answer the question. But so what we're going to do is just going to get you guys thinking a bit about banking and what it means, how important it is, and the systems that are in place that involve that there. So we're going to go through and do that, and then and we'll see how we go. This lecture should be much, much shorter than previous ones, so we're going to go and
So, excuse me, sir.
yeah, Staines, hey.
Yeah, hi, sir. I just need to ask you one thing. Like the last assignment which I submitted last day, when I did the submission, like all the documents were not uploaded into it.
Oh, that's right.
Like
Just
when I view,
email
yeah,
me through. You guys are probably aware that I do the business online, so I'm one of the tech support people for the college. In fact, now for 3 colleges.
Okay.
So that I got no problem with the technical aspect of it. So anything like that, you can email with me, and I can just go back and check audit trails. So
Yeah, exactly,
don't
sir.
stress.
Like I have sent you personal
Yep.
messages, and I have called you personally at that particular time,
Okay.
and also I've sent you the attachment of that particular thing which I
Yeah,
have
that's fine.
done
That's fine.
completely
This,
at that time.
yeah, I'm
It's
not.
totally fine, right?
Yeah, that's fine. Just email things through to me, and I'll be able to sort a lot of those things out.
Okay, sir.
And that's
Okay,
true for
thank you.
everybody, by the way. This is rather than just be a one-on-one. That's true for everyone. So if you do have any technical issues, particularly with the exam, I'll be the technical person in charge of this exam, as well as the person, obviously the lecturer for it as well. So there's no. I really just want you guys to not stress much about that. Even you, Hina, even you, not stressing. We don't want to stress about this. It's going to be made.
Okay.
Simon, I had temperature for 2 days.
Oh no,
Stress is in my blood. I
it
can't
is. It
even
is in your
even if
blood.
I've done everything perfectly, I still stress. I'm like, what if this happens? What if this happens? What
Okay.
if I'm submitting it and the system stops
Well,
working?
the system, it
I
doesn't
think
matter because your
all of the
lecturer
things
is
that
the
can
tech
happen.
support person. That's the massive advantage you have for this subject. I'm the person who looks after both. So you give it a good go. Start with the stuff in the slides. Have a good listen to the material today. And because there isn't a lot of slides, ask questions because the arguments that you guys have and the conversation you have, that really builds the learning in this style of the style of education.
Simon, in the end, my husband was literally like begging me. He said, I literally request you, don't take the other semester. I can't see you like this anymore.
Okay.
You don't smile. You're always stressed.
It's
Don't take another semester. Just relax for 6 months.
Um, yes, although I have to say, don't do like me, who did exactly that back in 2004. I took a semester off because I just finished my graduate diploma, and it was in accounting, an accounting major. And then I took 6 months off, just went back to have a full-time job, and I loved it. And then I changed jobs and never worked in accounting ever again. So I have to say that's a like that. Accounting's not so bad in that you can carry on doing it. This accounting and the MBAs and things like that, you can carry on without and give it a bit of a gap. Some disciplines really um, don't lend well to that. Has anybody here done pure mathematics? Have any of you
I
guys?
have done accounting, Simon, but I've lost interest in that now.
Oh, okay.
I am towards the other area now.
That's good. Well, the other thing is that you find you guys will you'll you don't know what you don't know, and so part of the education process is not just learning the content and learning how to combine concepts and things. It's actually learning things about yourself, what you like and who you are. And that's why it's fine when we're doing this, when we're in our teens and early 20s, because we're developing as people anyway. But don't lose sight of the fact that even when we do this later in life, which a fair chunk of people in this class are doing for this subject and for the whole MBA and MBA course, um, you should be a different person by the end of it. And I think this subject in particular, for many of you guys coming from different education systems, you get exposed to you know some of the good bits and some of the bad bits of Australian culture because culture flows through your laws. There's a very close interaction between these things, so that it's yeah, you guys are not going to be the same people. I can guarantee you, none of you are the same people that you were back in February or whenever we started this for reasons that we didn't quite think were going to impact the entire world. So it's been an interesting time. Um, but anyway, but definitely, I encourage dialogue as part of these things, guys. So don't feel at all bothered to flick your mic on and ask a question. Okay, so we'll kick it off. We're going to look at banks and banking. In fact, while we're there, I'm just going to grab a book. Yeah, it's literally this time next week. So we're going to be doing during this time, whatever it is, next Thursday. And there's a pause. Okay, cheers. Cool. Look, the window's going to be a little bit wider than that. I said it'll probably be a 2-hour exam. I'm going to give you guys a wider window to do it. I'm going to leave it as a 2-hour exam, but it's going to take much less time to do it. Again, for those that have talked to people that have done the subject earlier, they always felt pressured for time, particularly for the English second language types. But I think it's just easy to, and because you'll get it out and done. It'll be just done and dusted. And you can, yeah, you'll be able to concentrate on other things.
Okay,
Also,
if you compare it with assessment 2 and 3,
mm,
then how would you say? Like
the exam will
assessment 3 was
be
also open and
comp
done, like
the
4?
the exam will be comparable to the take home assignment in terms of difficulty. Did you guys find it particularly difficult? The take home exam? I'm interested
It
to
was
hear.
not difficult. All I had to do was listen to your slides again and
Okay,
again.
all right, that's fine. That's good.
I
That's
did
fine.
not mind that. But I
Yeah.
was hearing your voice even when I was sleeping.
Oh, you poor thing. I'm so sorry.
I
Cheer,
could hear
bro.
you all of the time.
My my thick Kiwi accent started to disappear over time. Um, yeah, so that's the key thing. So it'll be a series of small questions. So rather than have a single word document, depends on the marks. Well, yeah, true, too true. Um, this is true. Okay, so I'm just going to grab something. I actually have a really interesting book that I found. I'm just going to grab it off the shelf. I wanted to show everybody my book because I was for this subject went to do some research on banking. So I found a book. All right, this book. You guys can see that in the little picture down the bottom. It should be Hubert's Laws of Banking. Okay, yeah. And I started to open this book, and I'm just having a read of this book about this, that, and the other thing. I thought, oh yeah, interesting. It's got things, and it's all got the yeah, it's a little bit old, but it's got all the contemporary referencing and this, that, and the other thing. And I'm reading it. It's talking about the role of the banker.
How
And
can you read such a thick book?
it's a thick book. Well, you usually only just flick through to find bits that are interesting or that you find get value on. Usually, law or legal research is to find a specific to solve a specific problem that you're doing at any given time. I really don't want to damage it because I was reading it and it was talking about the role of the banker at common law. Then I was like, how old is this book? Because the Banking Act is from the 50s. Can you read that at the bottom? Published in 1904. Yeah, it's been around a bit. So this was sitting in the Law Staff Library, and this book is over 100 years old. So when the Staff Library got disbanded, I said, "Oh, I'm gonna keep that book." So my Law of Banking book is tad behind the times, but oh well, some things don't change. Um, well, that's not strictly true. A lot of things change with banking, and we're going to talk about cryptocurrency stuff a little bit later as well. So, um, so basically, this definition of the banker comes from the common law, but there's very, very little common law rules. Parliament has intervened because banking is such an integral, important, and essential part of contemporary society and economy. Some of you guys might remember the last time we had a great crisis, the global financial crisis of 2008. And the Americans, notwithstanding that they have this very strong libertarian culture that private business, government does one thing and business does other thing, and never the twain shall meet. Nonetheless, the Obama government went and bailed out the banks, and as did the Australian government as well. They said, we are going to guarantee everything the bank is doing. Why? Because if the banks fail, everything fails. It's so important as part of our economy. Yeah, I am. Yes, yes. They're both being recorded. So it's streamed to YouTube and it's in Collaborate as well. Banking's super, super duper important. And as such, it's heavily regulated. Very, very, very heavily regulated. So that this aspect of our society is governed almost exclusively by statute, the will of Parliament, and they it's a two-way street. Like a lot of businesses in Australia, you guys may find it odd. I found it odd as a Kiwi that some industries don't have a level of competition that I remember seeing in New Zealand. Supermarkets, for example. There's basically two supermarkets, two big ones, And so they essentially act as a duopoly. And so that yes, they do give consumers a whole bunch of lovely benefits. You can take things back and get a full refund and this, that, and other thing. But they do kind of milk it somewhat. And the banks are like that too. There's a small number of them, and it's really hard to get a banking license. I think there's 19, I think, different banking institutions. They're called authorized deposit taking institutions, or ADIs. Sometimes you'll see that in the banking literature, where they are the big players, and they're separate and distinct from small people. Now, in the olden days, any person who collects money in honest checks is considered a banker. You can't do that now. These days, the Banking Act in 1959 expressly disallows individuals. So you have to be a corporation, and you must be one of the authorized corporations on that list in the Banking Act. Also note that that both banking and corporations, those are two heads of powers that are for the federal government to exclusively go through and legislate over. In those two section 51 sub 13 and 51 sub 20 for banking and corporations respectively. All right. So what do banks do? All right, so they've got a bunch of duties. And again, these flowed from the common law duties. Now they've all been enshrined in statute. It's a bit like they see things like directors' duties. Yeah, there's some common law ones. When you do company law, you'll also learn that largely we use the statute. And I mean, I can go through this list if you like. Honor customers' demands and payment. Right. One of the first and primary reasons that we have banking systems and structures in place, if you stop and think about it, is to do with the ability to lend money for large-scale projects. Now, in week 2, I gave you guys, it was supposed to be a 5-minute talk, but turned into a 55-minute talk. And I talked about the Bank of England, which was really the first large bank where individuals could go in and deposit their 5 shillings and earn interest. And that was a novel thing. But one of the advantages of doing that is that as a bank, you then have a source of money. So what can you do with that? You can lend it out at a higher interest rate. But one of the key things that banks still have to do is that when people come and ask for their money back, is to give it back to them. Now, most of you guys have studied economics at some stage, so you'd be aware that that can sometimes be a problem. Happened in Greece a few years ago, where because banks will take your money, say they take all of money, each person in the class, they would take our money, we all deposit say $1,000 each. What it'll do is it'll then keep some of that as a reserve, like 20%, then lend out the other 80%. Okay? And so that in any given moment in time, this is the difficulty, if all 22 of us went back to the bank and demanded our money, that's a problem. Because the bank doesn't have all of the money. It's lent it all out. Or rather, it's lent 80% of it out. And so that can cause panic. And so you hear this concept of, in English, the phrase is a run on the banks. That is where there is widespread panic that the banks no one bank can survive it. That's right. So that's why during the global financial crisis, so the question on for the YouTube listeners, Enrico made the comment that no individual bank could survive that. If everybody demands all their money at once, you're right. If everyone demands all their money at once, as a bank, you are stuffed. You're absolutely done. Your bank will fold, and most importantly, everybody after the first 20% is not getting their money back. At least they're not getting it back straight away. That's problematic. That is called a run on the banks. Okay, yes. So so Nathan's made the comment: is there provision with the central banks and 7 times their assets? Yeah. Okay. There's a couple of points there. Yes. So banks, they have a certain amount, a fraction of their assets that they can lend. So they can lend again. When I did economics in the 90s, it was like we just said it was 80%, and you had to keep 20% that you weren't allowed to lend. They had to be retained for the day-to-day transactions. and you had to settle with the central bank at the end of each day. In fact, up until quite recently, like 20 years ago, the banks would actually physically, and I'm not kidding, drive trucks of money to the main bank. They would all, each of the big banks in Australia would have, and New Zealand as well, would have a little area where you'd have the Reserve Bank, and there would be notes, and you'd literally have to drive the notes into the Reserve Bank or to take them out again at the end of a given day to balance things up at the end of every day. Silly, eh? Now it's all done electronically, of course, because there's this aspect of trust is there. But when the global financial crisis came, Australia and the US and a bunch of other developed economies said, look, we will guarantee all of the banks. And so what that meant is that, well, in some ways it wasn't really that good, because it meant that banks that played a little riskier, in other words, they pushed their lending limits to the limit they possibly could, and they tried to get as many loans as possible, knowing that if there's a run on the banks, they're done. They were sort of saved by this. In other words, their risk profile, which was a higher risk, became underwritten by the government. And so they had a great time because, in theory, their margins were higher. What you found, though, is that institutions that weren't banks, so that so there was a company in Townsville called Storm Financial. It was a credit agency, but it wasn't an ADI. It wasn't an actual approved deposit-taking institution. It was a finance house, and the government didn't back those, and a whole bunch of them went broke, and everyone who invested in them lost their money. So it was one of those things. If you were either an official bank, you invested there, that was fine. If you went through any other sort of financial entity, a lot of them went broke during that period in time. Okay. All right. So banks have duty to. They've got when people ask for money, the bank has to pay it. Has to pay it back out, and to follow other lawful directions that the customers give, including things involving checks, writing a check out, which is an instruction to deliver money to another person. Receive deposits and collect the proceeds of checks to the credit of the account. In other words, when you take your money into the bank, they are supposed to receipt it, and they're supposed to take custody of it. 99.999% of the time, when you take money into the bank, right, you don't need those specific dollars, those specific bills and coins back. They count it, and they say, okay, this is now deposited with the bank, and we just increase the amount that we owe you by this much. That's why when you look at your bank statement, you see debit and credit. But whenever I've looked at it, I thought, hang on, aren't they backwards? Because the more money I've got in my bank account, it's a CR balance. You guys ever notice that? You guys are aware what I mean by debits and credits in accounting? Debit's the left-hand side, credit's the right-hand side. So, that idea that if I increase my assets, that's debiting. Debit, increase the assets, and if I increase a liability, that's a credit. All right, and then the double entry bookkeeping means that those things have to always balance each other. But when you look at your bank statement, when you put money into the bank, it says the credit balance gets higher and higher and higher. That's because from the bank's perspective, they owe you money. You are their creditor. And so that if you think about that, whenever you're looking at a bank statement, it's from the bank's perspective. That's just leave that in the back of your mind. This point onwards, you look at that. So from their perspective, if it's a debit balance, you owe them money. You've spent more money than what you had with them, and so that they're happy with that. They can get that money back off you. Okay. What else? Maintain secrecy. This is one thing. Banks, they are fiduciaries, so they have a duty to not give out your records to all sorts of people. Again, that's a combination of statute and equity. Exercise reasonable care in the advice or information provided to customers. They have to go through. Otherwise, they can be sued in negligence. Give customer reasonable notice for closing the account or determining, in other words, ending the relationship. The bank can't just chop you off. And the reason for that is that banks would be able to leverage that unfairly on small players. There's only a small number of people are allowed to be a bank. Small number of companies are allowed to be banks. It would be very unfair if they were allowed to just chop you off as a customer at short notice. That would come at a great material cost and be of grave risk to you as a bank customer. Hina, yeah.
Simon, why would a bank want to close a customer account? Like they
Um,
want us to.
if they thought that there was some risk through that they've done their own analysis as part and parcel of that, or going back to the run on the banks, if they thought people were going to demand money quickly. Also, if there are some form of irregularities as part of it, because anything that's irregular or unusual is risky from the bank's perspective as well. So this last thing, this item number 7, to care for documents out of hours. Look, banks don't usually do this these days. I'm not even too sure whether if I go into my local bank, because I worked for the NAB, so I bank with the NAB down in Aikenvale. I don't even know if they if they still do this these days. But in the olden days, you could take specific things. When I made that comment about notes, if you take in a bunch of banknotes, give it to them, they count it, they put it in the little tray, and they just increase the balance of your bank account. All right, but you can take specific items, jewelry or documents or other things, and the banks can look after that. It's a service that, I presume they still do it, but I don't know if all branches do it. I'm not sure. I'm not sure about that. Has anybody ever done that? I've never protected it, and I suspect that it's a generational thing. That's probably a hangover from earlier periods of time and has just been continued. Oh, is it really? Oh, nice. Good work, Thanks for that. So, for those
Simon, we are from India and Pakistan. We have lots of gold. We can't keep it at home.
Oh, wow. Wow, okay. Sure. Okay, I see. In situations where you'd rather that they bear the risk of things going missing. Okay, that's cool. That's pretty cool. I like that. All right, left for safe custody. Like it. Okay, so that's the duties of the bank. You'll also find that bank customers have duties as well. So you actually have certain duties when you go in to the bank, and they largely involve things like checks. Why? Because a check, as we'll talk about shortly, is an instruction to tell your bank to pay some money somewhere. In other words, take money from your account and pay it to someone. And checks are fraught with danger. They are a problematic thing because they're easy to forge. There's a variety of problematic things. Look, I am going to talk to you guys about checks, but I'm not going to do it in any real detail. If there's an exam question, it'll be just a very, very small one. I don't like learning check law. I don't like teaching check law. I didn't like learning it. I felt that when I had to learn it 10 years ago, that it was a bit silly. I taught trust accounting last year, and I had to confess to the class that not only had I never written a trust account check, I haven't actually written a check since the 90s. It wasn't fun learning from Tom either. Cortano's referring to Associate Professor Thomas Middleton, who famously has taught at JCF for about 30 years, and he taught check law. In fact, I will tell you a story because this is a short lecture. Tom one time borrowed a pen, a whiteboard marker from someone in the class. Said, "Oh, a well-known community lawyer, Margaret," and so he was drawing the check on the whiteboard, drawing the check, and he even made the comment, "Oh, it'd be really funny if this was permanent." So he's drawn a whole check. He's written his name on it and then signed it. This huge, huge, huge big thing. And then he goes to rub it out and he looks at it. "Oh, Margaret, this is a permanent marker." And so then he's like, "Oh no, what do I do?" So he goes and changes the name to Bob Middlestone. And then just gets the curtains and just closes it. So the poor estates office people would have found that and just gone, "Oh." The only one person who teaches check law. Everyone's going to know who it is. Yeah, so sorry about that. If anybody ever had to see that, there's marks on the back of the nursing theatre, lecture theatre. That was us a few years ago. Okay, so do you guys you know what I mean by check though? It's a little bit of paper. You get them and they've become rarer and rarer and rarer because they're very easy to forge. It's basically you get the check, you literally write how much you want to pay and who you want to pay it to, and you hand it to them. It's a negotiable instrument. They can take that under certain conditions. They can trade it or transfer it to someone else. They're essential in Dubai. Oh, really? Yeah, I hear they are in North America as well. And yeah,
I've not seen it in here, but in India it's quite common
oh, really?
for
Wow.
traders.
Is
Yeah.
it really? Okay, interesting. Because I find that interesting because particularly they talk about banking and changes in banking, particularly in Africa. Africa, sort of, the last great continent to sort of, go through the industrialized and post-industrialization stuff. And I don't know, is there anybody from Africa in this class? I don't think there is this year. The last 2 years I've had a few. Um, but they've sort of, it's really interesting because they've kind of bypassed a whole bunch of steps that other countries have had to go through, and so the idea of having things like checks, and they sort of bypassed that and gone straight to internet banking as a mechanism for transferring stuff straight into cell phones without having to go through all of those steps in between, because even in a place like Australia, which is relatively high trust environment, check fraud is still a problematic thing. And when I worked in retail jobs in the 90s, we accepted checks, but no one wanted to because it comes at a cost. You have to check them, and you've got to call the bank up, and you've got to take all of these extra steps. And for small value items, it's not worth it. But nonetheless, if you are using checks, you as the customer have these duties. You can actually be held liable. Usually, where you've issued a check and there's been some sort of fraud and you weren't careful, you'll be the one who bears the cost of it. That's really the key aspect to it. And there are actually penalties under the Banking Act as well. Again, they're pretty rare they come up. But my advice is to be, wherever possible, avoid using checks. And there's the mechanism around that called bank checks, which I'll talk about in a little bit as well. All right, so what do the banks do? Well, the banks, much like the supermarkets, much like a lot of other industries in a place like Australia where there's only a few players, it's pretty common, where these industries have codes. And they don't have codes because they want to have codes. These industries have codes because the government of the day has said, you lot, so talking to the banks, you lot have been bad, sort yourself out and regulate yourself, or we'll do it for you. That's essentially both a carrot and the stick. If you guys do the regulating and you create these sorts of codes and you enforce them yourselves and you pay to enforce them yourselves, we don't have to do anything at all. It's wonderful from the government's perspective because they don't have to pay for any of this. The banks create it, the banks enforce it, and if it works, and there aren't grave difficulties with it, which turns out that there was a thing called a Royal Commission over the last few years. The banks have been a little bit naughty. But where these things work, it's an industry code of practice, and Parliament doesn't have to do very much. And so here, what they've done is they've got all of the banks together to say that, look, okay, we don't have to do these things by law, but we want to be responsible corporate citizens, and thus we will regulate ourselves. But we'll do it ourselves so that Parliament's not doing it for us. Because if Parliament does it for us, they might impose much more onerous and costly things on us. So that's really the balancing act that you have with this style of voluntary industry regulation. I'm actually interested. Is anybody aware of similar arrangements happening in other jurisdictions, in your own home countries? Do they have voluntary codes across industries?
No.
Not really.
You have the code.
A lot of places they don't trust. You don't trust these players, or if there's lots of players, it's much harder to do these things. Australia, again, I think there's like 19 ADIs, so it's relatively easy for them to come together, have a couple of meetings a year, and even have a team of people organizing this, because at the end of the day, a team of like 10 people is just utterly irrelevant to one of the banks. That's just small change. I think the project team I was on, which had like 30 people or something, had a budget of $11 million, which, as IT projects go, is an insane sum of money. but it's a bank. Banks are great. If you're a problem solver, by the way, working for a bank is a wonderful thing. They solve problems by throwing money at them. So if you're a problem solver, they'll throw money at you. Good times. Okay. And so the code of banking practice has a lot of consumer and customer specific information in there. They're really things like that. Hey, when you get a new customer, banks need to provide the terms and conditions, the fees. They have to tell people what's happening. They aren't allowed to provide unreasonable fees as part of these things there. When they're doing guarantees or they're doing loans, they've got to make sure they go through all of these steps. And look, partially this has flown from the common law as well. Remember things like Amadio's case where the banks acted badly and the courts had to jump in and say, when the bank acts badly, we're going to rule against them. And so this is the sort of thing to really try and increase the I guess it's almost an ethical standard in the particular industry. And so really that's the advantage of going through and having these types of arrangements. So have a think about that. Like I said, I'm not going to look, I will put a question on banking in there, but it's going to be something pretty basic. I'm not that interested in that. It's more for your general knowledge. Okay, and similarly with checks, yeah, we'll talk about checks. Check, again, as I'd mentioned, it's an instrument. You get issued a checkbook and you write the thing in, you write the name of the person you're writing it to. It has to be, in fact, there we go, is the definition there, an unconditional order. It's addressed because it's addressed by, essentially it's by me to my bank. It's actually me asking my bank to pay someone. That's essentially what a check is. It's demanding that the bank pay when asked a certain sum of money. Okay, that's what it is. And again, the Checks Act, Commonwealth legislation, it's heavily regulated by Parliament, and there are a few different types. All right, so you have the payer and the payee. So the person who's being paid is the payee. If you can identify that person with reasonable certainty, in other words, it's not addressed to cash, then that is an order check. Word of advice. If you have an organization, don't call it something like the Computerized Accounting Society. And I'm not kidding. There is actually a case where this happened because the Computerized Accounting Society, what does that abbreviate to? CAS.
CAS.
Yep. So what do? You just put a little H after it, and then voila, the check, instead of being made up to a person, is now made out to cash. And so that aspect of it is, I mean, it's hilarious, but this is actually a case. It genuinely happened. There is a case, and I think I don't think we went to the full federal court, but I'd have to go back and check. We certainly had to study it a while ago, but it happened early 80s, I think. Okay, now you can, where you've got a check that's written out, you can actually have a check that is to pay somebody and have that be transferred. You can actually have, rather than pay this person, we're going to pay this person instead. Right? Still coming from the same account, but you can change the target essentially. So an order check, you can do that again through signature delivery and clear intention. You can go through to do that. You can go through and have checks passed on. You can also have what's called a bearer check. That is where you haven't got a particular payee. You just say, pay this person or bearer. In other words, this person or any person that rocks up and with the check and says, please pay me now. You can cross checks, and you can put a little thing on the check that says to make it not or bearer. Sorry, it's on the next slide. What have we got the next one here? It seems like this is really loose, this area of law, because you can have this bearer check, you can literally give it to somebody, and then they can give it to somebody else, and the person who physically walks into the bank can do it, can actually go and do it. And again, you can assign certain things to make sure it goes into a bank account, but sometimes by default, it's going to, they can take it out as cash. But note that you can take a bearer check at any stage and cross out the little thing that says or bearer and convert that to an order check where the payee is identified as part of that. So there's a bunch of curious phenomenons here. They're curious rules, but basically, if you get a check and you write two parallel lines, okay, that's you see that sometimes, and certainly if you get given a check by an organization, if the phone company, Telstra, whoever like that, has to give you some form of refund. The check that comes in a little piece of paper has the two lines in it. Those are the two parallel transverse lines. That just means it must go into a bank account. Okay. Then you can also inside, I'm not sure what has to be inside the two parallel lines, or they write it next to it. We have the words not negotiable. What that means is that the check can be assigned, but you can't change the payee. So what does that mean? It means that you can give it to another person, and they can give it to somebody else. You can assign the rights to it, but you can't change something you can't change. You can't change or give them the ability to give it to somebody else. So that thing can only be done. It can only be done once when you go through and do it. We talked about the Nemo DAT rule in terms of having good title and those and people. Now, there you go. Close your mic. I'm gonna mute you, bro.
Yeah, bro.
Mute. He got muted. It just means if somebody steals it, that they can't get good title. So if there's a person that steals the check and then tries to use it, they're not going to get better title than the person that that originally had it. You can also put account pay only. That is actually not a rule. That is just giving notice to the collecting bank, in other words, the bank that the person's taking it to get them to make inquiries. Basically, it means get them to ask for ID and to check. So if there are things on the back of it that the check has been assigned, then they have a duty to go through and check it. Now, hilariously, I love this story. The same Associate Professor Thomas Middleton, who taught check law literally for 30 years here, went into the bank and tried to go through and take a check which had been signed over at due course. In other words, it had been negotiated from one person to another, which you can do. You can change the name, you can sign it, and through the delivery. That's fine. You can do that. But the bank refused to accept it, and they said, no, we're not going to accept that. And he's like, no, this is good. No, this is good. It's under this 54 sub 10 or whatever of the Checks Act, and they still wouldn't take it. So even if you are literally the expert in this particular area of law in the entire city, doesn't make any difference if you rock up to the bank and they go, nah. Yeah. So checks they're an odd area of law. Be careful when you are using a checkbook. Be careful you physically keep it. Be careful that you go through and do these things. A bank can refuse it. Yes, they can. That's the thing. They can if they have some suspicion that there's something not right with it. Okay? The trouble was, when you're dealing with bank clerks, most of them don't know all these rules. Okay? So they can just say, we think something's wrong with it, even if everything had actually been done according to the Act, because you're dealing with bureaucrats. All right? That's just, and again, this is something as a practical mechanism. Always try to make life easy for bureaucrats. For anybody dealing with the federal government or the Queensland government or the council, always try to make their life easy. It's not about being obsequious or giving them bribes. Try to make their life easy when you're going through and doing it, because that way it saves time.
And Simon, you said if they are suspicious, right?
Yep.
In a case, if everything is smooth, they can still say we don't accept it. Do it this way.
Well, again, it's the circumstances. If you've got a check, all right, and it's been written to one person, then that's been crossed out and a different name has been put on, and it's been signed, which you can do. You're allowed to do that with checks, all right? provided it's not a provided it hasn't had the words not negotiable passed into it. You can go through and assign that, right? But when that happens, almost always you will rip the check up and get the person to write a new check. And this is what happens with trust accounts in law. Now, if you go to a law firm, they have to have a checking account, is what's called the trust accounts. And look, in theory, you can go through and do all of these rules to change the name on it, but in practice, no one does this. You just rip the check up, make a note that it's destroyed, and issue a new check. Go back to the person that does it. And that's why accepting a check is from another person that wasn't directly issued to you is fraught with danger as part and parcel of that. Because again, you can rock up to the bank, everything's in order, you know what the rules of check law are, but you rock up to the bank and they just say no, oh no, this is too hard. And even if you do get your own way eventually, it may take you a lot of time. And that's the key thing there. So that last rule, that account pay only, that doesn't actually mean anything in terms of the check itself or the laws or the rules. All it says is that please, collecting bank, in other words, the bank that you're taking the thing to get your money, if you've been given a check, your bank, that just tells them to be extra careful. All right, account pay only. And all standard form checks you get will have those words on there, and they'll be crossed, and they'll say not negotiable, because most organizations really try to cut down on the amount of fraud that can happen with checks. So just leave that in the back of your mind. So if you're writing a check out to somebody and you don't want to go through any of this rubbish where they can give it to somebody else, you're paying them and them only. What you need to do when you write the check out, you write their name, draw 2 lines across it. Inside those lines, write not negotiable. And somewhere else on the check, you write account pay only. Those are the 3 protections that you should do when you fill in a check that's going to one person. And don't ever negotiate them. In other words, transfer them to each other. It is fraught with danger. If, however, you do need to buy something, and buy something large, there is a specific type of check called a bank check. So I just got an email today from my ex-partner's solicitor that said, please explain the spending of a sum of money, large for me, sum of money, at the end of last year. All right. And I have explained it, which is I went to my local bank, NAB in Aikenvale, to get a bank check. All right. A bank check is not an ordinary check. You don't need to have a check account to get a bank check. You have to pay a fee. All right, you can do them online and it's like $12, or you go over the counter and it's like $20. If you need to buy something large, if you need to buy a car, you need to buy a boat, you need to buy a house, okay, you go to the bank and you ask them so your own bank, you go to them and say, please, can you print me out a special check for a certain sum of money for a particular person, okay? So you get all of those details on the person you're about to pay. You pay the $12 or the $30 or whatever it is. I'm not sure. It's a small fee. And you ask them to print out you this special holographic check. Okay? What you do as part of buying the car or the boat or the house, at the settlement, the point in time where you're exchanging details. So again, I did buy a car. And so when the guy came to exchange the car, we filled in the registration change details. All right. So we've filled in the details. There's quite a few forms you fill in. All right. We both sign that. And then he hands me the keys. I hand him the bank check. Okay. And because they're all holographic and they look very fancy, they're very difficult to forge. All right. So that you can go through and do that. So that's why, as I would recommend, in the very rare times you need to use a check for a large sum of money, that you go through that process to do it. These days you can do things electronically as well. So it's, there's a lot of ways around doing this. This is kind of old law. But nonetheless, you'll get a question in your exam about checks. It will not be very complex. If you listen back to these slides, if you listen to this thing here, look, you might not have time to listen to the whole lecture, so it helps to just jot down a few key points, take the slides with you, and hopefully just recall the stuff that you've got there to be able to answer the question. It won't be very complex. Okay, so contemporary stuff. Credit cards. Now credit cards are a little bit, they're actually a little bit tricky in terms of law, but they're a lot easier in terms of money. In other words, it's so much easier for us to use them than do things involving checks, because you have an arrangement between a few parties. So you've got the card issuer. So I'm with NAB. In fact, Alani's got my card. Can't even show you. Oh, actually, hang on. Where's my card? There we go. There's my card. You guys can copy my bank account details. Good luck with that. It expires in June. Okay, there we go. Good luck getting money out of this one. All right. So maybe I shouldn't be doing this in front of the car. I'll hold my finger over the last few digits. All right. So your credit card. So you've got these three parties here: the card issuer, the card holder, and the merchant. All right. So when you go and get a credit card, you go to usually one of the banks, although credit unions can do it. You don't actually have to be a bank to issue credit cards. That's the first thing you need to know. So these organizations, you don't have to be an approved ADI. The approved ADIs, most of them do have the ability to have credit cards, but there are a couple of large entities who essentially liaise with the banks to organize and facilitate this. So in this case, this is approved what? ADI. You might have missed that at the start, Hina. Banks in Australia, the technical term for a bank is an approved deposit taking institution, right? Or ADI. That's just the technical name for one of the, and I believe there's only 19 in Australia. I'd have to check. You guys probably did a bit of Google searching and correct me on that one. There aren't very many anyway. It's definitely fewer than 50. In order to actually be counted as a bank rather than just a finance institution. There are many more finance institutions, but they don't have the same backing as banks do. So, all right, we all know, most of us know how credit cards work. So the issuer in this case is, even though it's got Visa's name on it, Visa have a contractual arrangement with the NAB in this case. All right, so the NAB, the National Australia Bank, big star, big red star, they have an arrangement with Visa that says that we are allowed to issue these cards and we will deal with all the mechanical sides of it and we'll just pay you a fee, essentially to use your name as part of it. Okay, now when I go and use the card, so the NAB is the issuer, the card holder is me. I have a contractual obligation with the NAB. They're my bank as well. All right, but if they weren't my bank and I just got a credit card from them, I would have a contractual relationship with them. I will use the card under certain terms, and they will provide me with credit services. That's the way that works, and I will pay the money in a certain length of time. And if you pay it within a certain amount of time, you don't pay interest, and then they pay a higher rate of interest for this, that. That's how the arrangements between the issuer and the card holder work. When I come to the merchant, if I go to Otto's up at uni and I get my card and I go blip on the little pay wave, the money, that contract, strictly speaking, right? Remember, the contract is between me and the merchant. Okay, so the merchant being Otto's. All right, but the reason why this is a three-way contractual arrangement, I have an arrangement with the issuer that says when I do this and I hold the card over the little machine, it's an instruction to my bank to take money out and give it to the merchant. Okay, so you've got a three-way contractual arrangement between the parties. All right, that's just how that works. So when I sue, if I'm suing in regards to the payment or non-payment, or the product and the non-product, that's separate and distinct and completely unrelated to my bank. My bank don't care about the contract I have for coffee. If, however, I'm using my card and it declines for whatever reason, and I'm going to suffer some form of harm, my provider might be in breach to me as part and parcel of that. It still doesn't change my contract with the merchant, but they may be in breach of contract between me and my bank if they have not fulfilled their terms of that obligation. In other words, the card doesn't work even though there's money in there or what have you. Similarly, the merchant, all right, will have an arrangement. Again, Visa coordinates this. So the Visa guys, when you get the LeftBoss thing, they and so the people that run the LeftBoss terminals, they will have an arrangement with my bank. My bank's the one that's paying them. There's going to be a contractual arrangement there that said, "Oi, please pay us." And if that's gone through or doesn't go through or it gets reversed as part of that, then it might be something problematic that's going to change my arrangement with the merchant. In other words, the payment has been rejected. Or if it's some difficulty with their end, if the merchants themselves, the Visa company, have difficult time with the merchant, then that is a contractual arrangement between them. Me as the customer isn't involved as part of it. So it gets a little bit tricky when you've got multiple parties with a lot of these things. And it's important to separate out for any given contract who's part and parcel of it. Just me buying something from the coffee is just us two. So the other ones, we may have arrangements with those things, but usually they don't form part of it. PayPal. All right. Now, you'll notice in recent times that these sorts of systems, PayPal, have really started to increase in terms of the global commerce systems that come from that. Why is that? Because PayPal can be cross-border. It operates in lots of countries, but it can do cross-border or cross-jurisdiction transactions. Make note, they're governed by contract law, and if you have difficulties with PayPal themselves, not the particular merchant, but PayPal themselves, and you need to sue PayPal, they are based, I believe, in Delaware in the United States. You'll find that many, like over half of American, so United States America, based international corporations, got it. There is in Delaware because there's no sales tax, there's no GST equivalent or VAT equivalent, and so that's why they end up attracting a lot of people there because of that reason. Okay. All right, so just make note that it's still governed by contract. What you find is that when you have difficulties with merchants, PayPal will often be the ones who refund you. You think, well, hang on, but PayPal's not related to me. I don't have a contract. Well, you do have a contract with PayPal, but that wasn't me and the merchant. And that's because it's easier most of the time for PayPal to sort it out. It's actually easier to do that than it is for you to try and recover something from the merchant who might be in, Ontario, Canada, or they could be in Karachi, or they could be in, Cairo. You've got no ability to go through and deal things. So what we've developed is these systems that, look, it's better off to have these international merchants, PayPal, Visa, and so like, for them to essentially act as brokers between the various parties. So if you have difficulties, you contact the PayPal people, and that's why they have often things like insurance on transactions as well. So if you don't get your product, PayPal are the guys that will go through and sort that out. It sounds a little bit unusual, but the PayPal guys have realized that because they make so much money through doing and coordinating these transactions, it's worth it from their to get people to keep using their system to just pay out in situations where a merchant has sold something and not delivered. All PayPal have to do is just remove the merchant. All right, you're doing something dodgy. You just can't do this anymore. And so that's essentially how those sorts of systems work. Okay. All right. What else happens? We also have, and again, this is the last slide I think I'll do. I think this will be the last slide, then we'll take a break. Yeah, last slide before we take a break. Is it? Yeah, last slide, we'll take a break. All right, e-payments code. This is not an industry code. This is instituted by the federal government and regulated by ASIC, the Australian Securities and Investment Commission. And so basically it says where there are electronic payment systems, you have to follow a series of rules. You've got to talk about, stipulate where your terms are, make them clear, make them unambiguous, set out rules for when things go wrong, set out rules for who pays. So going back to the PayPal thing, when I said that usually recover from PayPal rather than from the merchant, those things have to be explained as part and parcel of it. And also a regime for mistaken internet payments. Has anybody done that? Paid somebody on the internet or paid the wrong person? Has that ever happened to anyone?
Happens when we recharge the mobile. It
Oh,
does happen.
nice.
It
Oh,
happened to me in India.
yeah, sure. Nice one, lovely. Did you get lovely? Did you get your money back?
Yeah,
Oh,
there was an honest man.
oh, nice work. Well,
Oh, I recently bought a card for my brother a week back
yeah.
because of the virus. I don't let them go out of the home, so I buy it online for him.
Oh, nice.
And I by mistaken send it to a wrong number, and my brother was like, just forget it. I'll message him and I'll say enjoy the credit, and then I had
Nice.
to buy it again.
Oh,
I
wow.
did not even think of asking it back.
Yeah, you find with these things you can. There are rules for doing it. So I had one. My best friend, she lives in Auckland, and she's sort of an heiress. She's Indian, but she's Gujarati, but she comes from Fiji, and is an heiress to a bunch of jewelry stores in there. So she knows jewelry really really well. And so when I was getting my engagement ring, I called her up and said, I need to get a ring and I make it look like a ring, so I get a big stone and this that. So she sorted that out. She said, "Oh, just send me the give you my details." And so she sent me her bank details because she lived in Melbourne, sort of 20 years ago, and went to the wrong account. That was some difficult times because you can imagine engagement rings. I don't know if you guys are aware, and in Western culture, the idea with the engagement rings and the days of ye old England was that engagement ring money, yeah, is that it's supposed to be back in the olden days, and I'm not kidding, marriage and this idea of having an engagement ring or was as a gift. It's not really a gift. It's consideration as part of a contract. If they don't go through with the marriage, it's breach of contract and was sued like you would sue for breach of contract. All right, going back hundreds of years ago. Okay, waste of money, handcuffs are better and cheaper. Yeah, I'm interested actually, and yeah, I'll ask Suprit or Ravneet what like how systems work with things like dowries. Is that still a big thing for people on the subcontinent? Oh, wait a minute, love it.
Not now. It
Okay,
was in like 5, 10 years before.
yeah,
It was really common, and
nice.
domestic violence used to start from there.
Yeah, it's something that I'd made the comment about that the subcontinent, that things at times are changing, and so that you'll find that things that the really progressive countries, New Zealand being a good example actually, where things have changed to give people rights, to make society more egalitarian, and to sort of really start sort of backstepping and re-examining older. I didn't ask that. Older traditions that sometimes they can be fundamentally unfair, and so that those that system and the dowry system, I believe it is something that's going and changing in the subcontinent here. It's but it's a similar sort of thing. The idea that you do have material things that are exchanged. So engagement rings, very expensive. So I'll tell you guys, it was I think it was I think 8,500 Australian dollars went to the wrong bank account. Yeah.
Are you serious?
Yeah, this is here. This is in Australia because it was my friend, and she had a bank account. She gave me the wrong details, and so that was a challenging thing to go through and do. Thankfully, the banks were able to sort it out, but it actually predated this code. I think it would have been, yeah, it was. It was a couple of years before this code came in, so that now, if that happened, the banks have a much better system for recovering things, provided you get onto it quickly. The trouble was we didn't get onto it particularly quickly. Then she divorced you and had to pay the lot. Yeah, I didn't get the ring back. But yeah, it is something you can leave this on the back of your mind that all entities that do electronic payments inside Australia have to adhere to this code, which means there has to be a system to try and undo things when people make a mistake. Like if you make a mistake and you're entering the wrong bank account number, the wrong BSB, the wrong thing, which is why when people send you the BSB, which is the bank something branch or something, I'm not too sure. It's the bank and the branch, which is 6 digits, and then you've got the account, which is between 6 and 11 digits. All right. Make sure when you do that, you don't have spaces or hyphens in it. So you're just copying it and pasting it. Copy and paste. Always make sure you do a copy and paste. Don't type things out again because that's fraught with danger. And even when you've got it, double check it. But even then, you can know that if you do make a payment and it's wrong, how much? By the way, how much did you pay for it? Yeah, it was. I said it was $8,500 for the whole thing. Yeah, it was a lot of money to send to the wrong bank account. I was very sad. I was very sad when that went to the wrong bank account, but it did sort it out in the end. But it took 10 months to sort out. So that was a bit sad, but it got there in the end. Got there in the end. Yeah, that was back. Hey, I was working for a bank at the time. All right, it's different rules. 1,500, something like that. I think it might have been a bit more. Either way, I'm going to leave it there for this particular part. We're going to come back and we're going to talk about some other things. We're going to do debt and bankruptcy, and we're going to do some things that are definitely going to be in your exam. So I'm going to give it a couple of minutes. Take a couple of minutes, and I'll be back in probably about 4 minutes. I'm just going to grab a drink. Okie dokie. Let's flip over. I put this in last year. I think we might have a discussion. Did you guys know what cryptocurrency is? Is this something that's entered into your world much?
Yes.
Buying things on the dark web.
It's a game for people that they know what they're doing.
Yeah, true, I suppose. All right. Well, for those that aren't aware, cryptocurrency is it's a ledger system where rather than have physical or a data file that just stores transactions, looking through the ref, Rafnit paid Sukprit, electronic no government. There you go. Based on trust. Oh my God, textbook. Kamal, well done. Textbook answer. Based out of trust. Yes, it is. The aspect of trust actually underpins not just all of commerce, but certainly all of transactions between people. Because if you stop and think about it, I had this argument again with the class about what this stuff is and why is it valuable. Why is Bitcoin $3,000 a coin or something, whatever, some amount? Why is that? And the reason for that is that that's exactly the amount people are willing to pay for it. That's how everything is worth. So when we're thinking about this cryptocurrency, the whole idea of it, yeah, exactly, is that it's a ledger. If I go and sell something, I don't know, Rakel sells to Ravnit, you sell something, as part of the transaction, you agree that you will give your little bit of Bitcoin to her, and because only you have the password, the key, so to speak, to access that particular ledger, to access that particular block, that particular record in the ledger, it's encrypted, so only you have it. So when you go through and do that, you can send a little thing that says, okay, in this particular chunk of ledgers, I want this to transfer from this person to this person. It's essentially like an ordinary database would work, except it's distributed, so that rather than having one place where there's one record, the Bitcoin files are distributed around the world, so that once you make this transaction within a couple of minutes, it's all duplicated everywhere and updated. A bit like URLs, web pages. The internet doesn't use web pages. The internet uses numbers, IP addresses. All that the domain name server people do is have a list of names and have a list of numbers and line those two things up, and you pay a sum of money to the big, the .com people and the .net people and .au or .nz. You pay a sum of money to them for managing those lists, and then they get distributed around the world. They propagate. And that's essentially all cryptocurrency is. It is a ledger that is encrypted and distributed. The difficulty is it's difficult for governments to come in and have a back door. What do I mean by that? It means that if the federal police come knocking, they can't unencrypt. This is important. They can't unencrypt the ledger. So they can't tell who's paying who. Okay? However, this is why I've never been worried about the law of technology. I find it kind of dull myself. People have asked me. I've been asked this question a lot. Why why I'm not an academic on the law of technology. I don't find it very interesting. Largely because it's stuff that's solved by government, and it hardly has any cases that go with it. And usually the cases aren't very exciting. The technology of the law, that's a different thing. But the law of technology, not interested. But in this particular area, even though the people can't get into, the governments can't get into the cryptocurrency and see who actually paid who. Did you pay, I don't know, Vladimir Putin $1 billion for some nuclear warheads? The government can't tell that. What they can do, though, when they've got enough sort of evidence, a small amount of evidence, is do an onus reversal. What does that mean? It means that, and again, I'm thinking here for the purpose of taxation, we can say, we think that you've made $10 million this year. Please pay us $3.3 million worth of tax. All right. If you don't want to pay that tax, that's fine. Show us the transactions. That's an onus reversal, where it puts an onus on you to show things. And look, parliaments and courts don't like doing this readily. Don't like doing this often because it's actually creating a duty on citizens. We don't do that lightly, but it is a pretty simple mechanism in this particular area to really overcome some of the technical difficulties with governments not being able to access it. Okay, don't talk about Putin. He's sweet. Yeah, like that. Always say great things about the great leader. I didn't get it. Okay, I'll start again. So cryptocurrency is a ledger that is just made of encrypted transactions between people that are stored, but rather than being stored in one place, once a transaction happens, it propagates to all sorts of other servers all over the world. Okay, so it's a distributed system, a bit like the internet, with servers all over the show, and governments can't get into it because it's encrypted. All right, so in order to get around some of these things, from a taxation perspective, you can reverse the onus. You can have, if the tax office suspects that you're evading tax, and they do this, by the way, by looking at what you have. Do you have, if here, for example, if I rocked up with a Ferrari, the tax office would get very suspicious. How does Simon afford a Ferrari? Please explain. And there's an onus reversal that says that we deem you to have earned this much money. You either pay that amount of money or show us your returns. It doesn't matter how encrypted things are if you have to show your information to the tax office. Okay, also note that cryptocurrency is not a currency. So Bitcoin is not a currency. It is a barter transaction. It's like you are selling stuff. Sunglasses, cans of Pepsi Max, anything else. It's like selling an intangible, because it's a digital product. Yeah, a bit like gold. It's a little bit like gold, but it's not tangible. But it's essentially, in our legal system, it's essentially the same. Right? It's a barter transaction. So what that means that whenever you do a transaction, right, this is important for taxation purposes, you have to get the market value of what things are. So if you get Bitcoin and you spend it on stuff, or people pay you in Bitcoin, the value of Bitcoin in terms of the market value in Australian dollars is what's used for determining the amount of tax you're going to have to pay. Okay, you don't get to choose what the stuff is worth. However, where you are in the business of doing things with cryptocurrency, then it's considered to be trading stock as far as the tax office is concerned. Okay, so just make note that trading stock, curiously, has you guys have to, I think most of you guys are going to be doing tax next year anyway. That trading stock has a couple of quirky rules to it. For example, you get to choose what it's valued at the end of each period, which is quite neat. Market or replacement or disposal cost. So you get to pick in tax law what the stuff is worth, which is a little bit, it doesn't sit very well with the idea when you're working out for your income in a period. You've got to work out what the amount at that particular point in time is, and that's in reference to the amount that you get if you convert it to cash. All right. Do you guys have any thoughts on cryptocurrency or any questions?
Simon, I don't know how it works here,
Yeah.
but when in our country, when one of the politicians who was the PM of our country and he was questioned from where did you get this, this, and this, and this. All he said was this was a gift.
Well, that's fine, and that becomes a
Yeah, but
question of evidence. So,
exactly.
but
Unfortunately, the
gifts
the
just
Prince of Qatar said I gave it to him.
yeah, just to point out that in our system here, under section,
Yeah,
I
yeah.
think it's 21 capital L of the Income Tax Act 1936, might be 23 capital L. If you get something as a gift, all right, but it is related to you doing something. It's not just a gift because you're a good person. It actually relates to something. That's income. It doesn't matter whether it's a gift or not from our tax perspective. I'm not kidding, if I go and help my friend fix their car, all right, I'm not very good at fixing cars, but if I go and fix their car and they give me a box of beer, strictly speaking, that's income. And I have to pay tax. I have to include the amount of that box of beer in my taxable income. Yeah, absolutely. That is the rule. People don't usually do it, but because you've got some evidential problems, but that is actually the way the
What?
law works.
Can you wait? You said if it's a present, it's not an income.
No, if it is a gift that is given in relation to personal effort or exertion, okay, so that if it's a true gift, for example, at Christmas or whatever particular insert religious festival here, you give people sweets at Halloween, for example. Somebody comes over to your house and you've made a salad and you give it to them. They've come up, you've just given them just to be nice. And there's no connection there between any personal exertion. This is tax law, by the way, not so much this subject. If there's no connection to personal exertion, that is a pure gift. If there is a connection to personal exertion, that's income. It doesn't matter. I mean, otherwise everybody would try and pay people as gifts. And you can't sidestep the tax system like that. Personal exertion, you get
Simon,
something
can you give
result.
one and two examples to clear it in my head? Because I am confused. How can this be an income?
Tips.
What? Does it not make sense?
Yeah. For example, Simon, tips.
Yeah, tips income, definitely income, absolutely income.
Doesn't mean it's taxable.
Yeah, of course it's taxable. It's income. Yeah. Yeah, definitely.
You're saying like if I go and if I buy a car
Yep.
and they give me something with it, just like that, that's also an income.
If they
I
give you
went to buy a
something
car
for
and they gave me
doing something
something.
else, if you're going and buying a car, that's not strictly speaking personal exertion.
You gave some example. I think I missed it. My son was a bit loud. Can you repeat that example when you were trying to explain an income?
If I go and I've got to be careful because I'm not assessing you on this, and it's not part of the subject, only other than the relation to cryptocurrency. But if I go and help fix my friend's car, okay, doesn't matter how bad I am in the car, I'm helping fix it, and he gives me a box of beer, that's income. And the amount that has to be added to my taxable income for the year is the amount that beer cost. That is absolutely the law of Australia. The fact that a lot of people don't do it, most people don't do it, all right? But strictly speaking, you are supposed to do that. And in high visibility situations, an example where that comes up, and I've certainly seen it in my own life, when you're going through a separation with your partner, at that point in time, you're in a high visibility mode because if, for example, I am, wanting to try and bypass paying tax by receiving gifts from people in the form of them paying my electricity or then, giving me food or them giving me things and for me doing business, that's a high visibility situation. As part and parcel. Yeah, which one? Ravneet, which one here? Which doesn't relate to the earning source? It does. These things are. If it's personal exertion, and you receive a gift that relates to that, then it is taxable. It just is. I can go back through some of the cases if I can remember them. Scott and FCT, I think, might be one of them. I'd have to go and check, but it certainly is. I haven't taught tax law for for 3 years though. 2 years. No, actually, I taught it last year. No, forget I said that. Yeah, I taught tax last year. Yeah, so it is actually. Look, it's not intuitive because most people don't do that, but it is actually. Oh, you're doing tax. You're doing it this semester. Okay. Oh, good luck. Yes, I have a friend who's a tutor. If you do need a tutor for tax, but you can send me an email. Okay. Anyway, that's enough about that. So cryptocurrency. Look, it's considered to be a thing that you buy and sell. It's bartered for. What I'm really interested to get to is this idea of debt. I'm going to bring the thing over. We'll talk about debt. Now, we've intuitively we know what debt is. Debt is this idea that it's the when amounts are owed to you from the result of previous transactions. So we're pretty familiar with what the concept of debt is. All right, and in accounting, we deal with debt. We have debt, and then we have bad debts, and you have provision for doubtful debts, and you do all of those sorts of things with debt. But here we're interested in terms of the law, because we want to know when somebody owes us money, what can we do about it? All right. So start off by just explaining what sort of some examples of debt are here. We've got mortgage. A mortgage is a form of debt that is attached to real property. Nathan or Kamal, what's real property? Or anyone? Marie, anyone?
House. Land.
It's land. That's real property. So a mortgage is a debt that is attached to real property. Or secured is the word we use. They're securities. What does that mean? It means if the debt isn't paid, the person who owns the debt gets a right to sell the house and recover the amount of the debt owed to them. Okay? Now, you can also have a registered debt attached to an item of personal property. We call that a bill of sale. And you can have a charge. Charges are usually used in the corporate setting, where you can either have it across a particular item. So in other words, for example, if you purchase a big printing machine for your printing company, the people who sell the printing machines, if you haven't paid them in full, they might say, okay, look, we're going to have a registered debt over this, and you can pay it back at a certain amount over a period of time. Okay, that's a charge. You can also have a charge across a variety of other assets as well. You can have security across those. And in fact, there's another way of particularly when you sell goods to another party, and that's just to have in the contract, title doesn't pass until these goods have been paid for. So it's quite common, by the way, whereas we're in business, for you to buy things and then pay for them later. That's the way that a lot of business works. And again, you've always got this sort of trust mechanism. We don't do it as consumers. When we go to the supermarket, we don't walk up and say, oh yeah, I'll come back and pay you later. With business, they have much more of this aspect of trust as part of it. In fact, I found it really strange when I started, me and my friend of mine, we started a business about 20 years ago. I was 22 and he was 19, and we started our business together. And we found it just bizarre that we could walk into the computer parts dealers, and we had an account, and they would just give us the stuff and we would pay later. We found that that's the most bizarre thing, but that's the way business works. It's the way it works. And this idea of not letting title to goods pass until they're paid for it's also known as a Ramalpa clause, and it comes from that case at the bottom of the screen, that aluminium industry and Ramalpa aluminium. So basically it just says that, look, if title doesn't pass and then the company goes broke, right, you still own the things. If they haven't paid for it, you just walk in there, grab your stuff and walk out. It's still yours. You own it. Goods that haven't been paid for. So, and you can put that into your contract. Again, the Sale of Goods Act has a specific clause for going through and doing that. What are other examples? Possessory lien. I talked about this last week, a few weeks ago. Possessory lien, that is where somebody holds on to your stuff until you've paid for them. So that example is the car. So if you go take your car in to get it serviced, they can hold on to the car until you've paid for those repairs. Okay. Another type of debt situation is a guarantee. Oh, these things can be tricky. That is where one person, often someone like a family member, will enter into a contract that says that if this person doesn't pay, usually a family member, so if, I as the parent will let my child borrow some money from a bank. If he doesn't pay it back, I will pay instead. I'm guaranteeing that particular loan. Okay, that was the situation in Amadio's case, where the Italian migrant parents didn't really understand what was happening, and they signed the thing. They didn't know they were signing a guarantee, and they would lose their house if the son's business went bad. That's how and where those things work. So those terms are probably worth committing to memory, to some of the more technical sort of language. So, okay, we've got some debt. Let's just imagine we've got a business. All right, so collectively, pick some years there. So Ravnit, Katano, and Hina, you three have got your business, and I am your debtor. Yes, you are my creditors. I am your debtor. I owe you money, and I don't pay. All right, so then we have to go and do things with the court system. All right, so this is a few things you need to know. First thing you need to know, as a technical term, the difference between a liquidated and a non-liquidated debt. It's an important point because the rules and procedures for recovering liquidated debt are much, much easier than recovering non-liquidated debt. So I'm going to explain this in a second. Liquidated debt is where the amount is not in dispute. So, for example, I bought the printing machine from Hina. I bought this printing machine. It was $50,000. I haven't paid any of it. That is a liquidated debt dispute. It's not in dispute that she delivered the machine. It's not in dispute that I accepted it. It's not in dispute that I'm using it. It's the only thing that hasn't happened is I haven't paid for whatever reasons. Now, if the reason that I'm not paying is because I think there's something faulty with the machine and I'm going to commence litigation or doing things involving not consumer law because it's a business transaction, but I'm going to go through the courts and seek some sort of compensation for breach and this, that, and it's part of that might be you might remember the rules for substantial performance. So you might be able to have the amount reduced to correct minor defects. In those sort of situations, the amount is in dispute. That is not a liquidated debt. If, however, I said, yep, the machine's great, love it. Yep, I'll pay you next week. And then you call up next week and I say, oh, yep, the machine's great. Yep, I'll pay you next week. Yeah, cash is a bit tight. How about I pay you at the end of the month? And then the month rolls around and I still haven't paid. We all know this feeling. We've been on this planet for a long enough time, and I'm sure all of you have had the situations where you've had that friend that you've lent money to and they never pay it back. Or you've had a business, unfortunately, where money's been lent and that business goes into liquidation. Okay, so just make note. Liquidated debts are where the amount's not in dispute. And again, usually do this through evidence, written evidence. If they're saying the machine's got problems, I want to pay less money, or we're going to have an argument about what the amount's going to be, that's not a liquidated debt. All right, that's going to have to go through a full process in terms of the courts if it has to go to court or some sort of alternative dispute resolution. Because liquidated debt, there's some cool things that come with it. One is that you can go and get what's called a default charge, which I think I'll talk about a bit later. When things are not in dispute, you can also on-sell it. Where amounts aren't in dispute, debt can be assigned. You can actually go and sell it. So that's why you'll find if people don't pay their phone bills, those amounts get sold to debt collectors. So what happens, these Bay Collections and these sorts of debt collecting agencies, they will agree to buy the debt from Telstra or Optus or whoever for a smaller amount. So 50 cents to the dollar or 10 cents to the dollar, a smaller amount. From the Telstra's perspective, that's fine. Look, it's not worth their while to run around chasing, particularly small sums of money. It's happened to me once. Oh, it's the worst. Dealing with debt collectors is the worst. worst. They are the worst. Just it's such a terrible industry to be in. And it takes a certain type of personality, and those types of personalities are people with broad shoulders and thick necks and tattoos, baseball bats and stuff, cricket bats. This is Australia. Okay. Note there, I've got a note at the bottom that QCAT, where you've got a liquidated debt dispute, QCAT can actually do this for small amounts. So just leave this on the back of your mind. If there is a liquidated debt dispute and it's a small amount, you can go to QCAT to have the thing resolved, okay, and get an order. All right, that would happen, particularly when the amount's not in dispute, and particularly if the other side doesn't turn up. QCAT can be a low-cost mechanism for enforcing that as part of that process. For more and for larger things, though, we have to go through a more complex series of legal steps to go through. Okay. All right, so we'll need to note that. Now, all right, this next bit, I've been quite looking forward to doing this. This is new. Now, I'm sorry that there's a little bit of a wall of text. It is a bit of a wall of text, but you're probably going to have to note this because this stuff is huge in business. Okay, I probably should have done this as 2 slides. Sorry about that. But when matters are going to go to court, okay, the idea of making offers to settle is of vital importance in strategic decision making for you guys in business. It's huge. It's a huge, huge thing. The reason for that is that by default, when you go to court, you're going to have a winner and a loser. We live in an adversarial system. Somebody's going to win and somebody's going to lose. So say, for example, again, going back to the printing machine here, printing machine, maybe a boat. I'll put a Ravneet. Ravneet sold me a boat for $8,000. All right. I think that the boat is defective in some way, and so I only paid her $3,000. All right. So we're now arguing about a sum of money. She wants the extra $5,000. I don't want to pay the $5,000. Okay. We're in dispute about this thing. Now, if this matter goes to court, it's going to be expensive. If you're going to have, both sides are going to have to go and hire lawyers to go through and do these things. It just ends up being very, very, very expensive as part of it. So, now, to encourage parties to not go to court, Parliament and courts, so both the courts and the lawmakers, the judicial lawmakers and legislative lawmakers have come up with a series of rules. And these rules say that, look, to encourage people to not go to court, we are going to modify the standard rules for paying costs, legal costs. Because the default rule is, and this is the first thing here, the first point, if you go to court, so Ravneet and I are going to court, one of us is going to win, one of us is going to lose. So let's say that she's suing me. She's the plaintiff, I'm the defendant. We'll say the amount, we'll say it's $500,000, not 5, because that's a little bit tricky. But say she's suing me for $500,000, all right? She has to then go and get some lawyers, and she may have to spend $10,000, $20,000, $30,000 on lawyers. I may have to do the same, all right? And we're going to go to court. Somebody's going to win, somebody's going to lose. So let's say Ravneet wins. So the court orders that I have to pay her $500,000. Sure. Now, because she's won, I have to pay her costs, her legal costs, all right? But I don't, by default, pay all of her costs. I pay an amount, what's known as the scale costs, or the standard basis for calculating costs. It is a low number that almost all lawyers that you'd ever hire would charge more than. It's a low basis, and there's a scale. It's in the, I think it's in the, I'm not sure which, Civil Procedures Act, Civil Proceedings Act. It's in a piece of legislation, there's regulations that go with it, that says for every photocopy page, it's 25 cents. And for every hour that the lawyer spends, it's $70. Now, have you ever found a lawyer that works for $70 an hour? Anybody found one? You don't find very many. My lawyer charges $330 an hour. Bless her.
If you're a lawyer, you don't need a lawyer.
No, you should always get no. Well, sorry, that's not strictly true. I don't know whether I should delve into this. There was actually a case in the Australian High Court last year that said lawyers. There used to be a rule that if you're a lawyer and you go to court representing yourself, you could get costs against the other side. So you could still claim legal costs, even though it was you bringing the action and doing it all yourself. Right? They've actually stopped that rule. They stopped that rule last year. The High Court unanimously said, no, that's a dumb rule. No more. And it's really to encourage lawyers to go and get other lawyers to represent them as part of it, because you end up making bad decisions because you're so closely attached to it. It really messes with your brain. I'm doing most of my legal work myself, but that's largely because I'm cheap, and because in family law matters you often don't get costs. But we'll get back to that. It's actually pretty good. It's a good question. Also, appreciate that, like with other professions, you have your area of expertise. All right. So my area of expertise as an academic, I'm an academic. I'm not a practitioner. I'm not a barrister, and I have a volunteer's practice certificate. So I do volunteer legal work, and my area of research is in legal writing itself. And so that there are some areas of law I'm not very good at. Secession law, I don't know hardly anything about that. You have wills and this, that, and the other thing. You can't know everything in a particular profession, and it's really about sticking with what you do know. So family law, I never actually studied family law, and so I was at a bit of a disadvantage. I tell you catch up pretty fast. Now I'm capable of doing it on my own, but you wouldn't normally go through and represent yourself. Usually, with small matters it's fine, but with large ones you really wouldn't want to go through and do that. Okay, now assuming that both Ravneet and I have got lawyers, we've each paid $30,000. All right, I've lost, so I'm going to have to pay her the $500,000, and I'm going to have to pay the scale costs, which is it usually comes to about a third to a half of what the amount that she actually paid was. So she'll get $500,000 from me plus an extra probably between $10,000 and $20,000 for the for what we call the scale costs, because she won and I have to put money towards her costs. Okay, that's the first thing. That's the starting point. Now, that's the standard basis. The other basis you have is what's called the indemnity basis. In certain circumstances, rather than me paying the scale costs, that I said it's usually about half the amount that you pay a lawyer, the court can award, and sometimes, the full amount. So I would have to pay Ravneet's all of her legal expenses reasonably incurred. All right, that can happen, but by default it doesn't. By default. All right, and there's reasons for that, which we'll get to. Because to try and encourage the parties to settle, the courts and parliaments have created these rules. And it goes like this. If Ravneet and I, for this $500,000 dispute, if I make an offer to her, right, as the defendant, all right, and she goes still to court and says, no, I don't want your offer. Say I offer her $400,000. Hey, I'll settle this matter now. I'll pay you $400,000. And she goes, nah, not good enough. I'm going to court and I'm going to ask for $500,000. All right. If she goes to court and she wins $500,000, my offer is ignored. It didn't make any difference. I'm still going to have to pay her the normal amount. All right. If, however, she goes to court, but the judge only awards $300,000. All right, we've got something of a problem here. And this is the way you should think about it. she's the plaintiff, all right, and we've got a proceeding. We're arguing backwards and forwards, and at a certain point in time, I've said I will settle this matter for $400,000, and she said no. Carried on to court. We spent all of this extra money. It's gone to court. Poor old, sorry, Ravneet, pulling out like that. She's gone to court and won $300,000. All right. What do you think should happen? What do you think a commonsensical rule should be to try and stop people from still going to court and not accepting the offer? It's not win-win. We've had to go all of this extra point in time and incur all of this extra legal expenses. If she had accepted my offer back here in time, we both would have been better off. Oh, no. It's not 7:45. Crash. What is with my computer? All right. I'll pause this. And we're going to carry on. So we have to stop this one here. Just give it a minute. What is it with Chrome? Every time, without fail, the same amount. Where is my laptop? For those who are on YouTube, I'm just rebooting. It's a tad annoying. Let's go. That is amazing. I have learned the most terrifying thing about Collaborate in Google Chrome. I think it is caching the video while it's recording in memory. Because I just looked at the memory use on my system and it was up at 2.5 gigabytes for Chrome. That's really interesting and a bit scary. So I have to do some more research about that. Because everybody will run into dramas at that point in time if they're running the session beyond a certain point in time, which is that's worrying, but that's a problem for tomorrow. Okay, I was explaining offers and this idea that if we've got a $500,000 dispute, I make an offer to settle for $400,000. I'm the defendant. I want to pay as little money as possible. Ravneet says no. Then she goes to court and only wins $300,000. What do you think the courts ought to do? What's the normative thing? What would be a good rule or system for that? Should she be rewarded for going to court if she's going to go and get less money?
No.
No. And as a matter of policy, we really want to discourage people from going to court and wasting the court's time. The court has only awarded $300,000, but I offered $400,000. So that is just a waste. She ought to have accepted the offer at that point in time. And so what we say here, this is this rule down the bottom here. What we say is that, look, if an offer is made, and you need to make note, these are the offers under the common law. We call these Calderbank offers, and you need to note those magic words. If you are ever in business and you are making an offer to another side to end litigation, you must use those words, those magic words at the top. Without prejudice, save as to costs. What does that mean? It means the letter you are sending, if it is only containing an offer to settle and nothing else, we will settle the matter for this amount of money. If you put the words without prejudice, save as to costs, it can't be used as evidence against you. It's a super important rule in civil procedure. Okay, that is a Calderbank offer. So if you are in the process of being sued and you think you're probably going to have to pay and you want to try and avoid it going to court, that is what you need to do at the top of your letter. Can you explain again? Sure. If you are being sued by somebody or you're about to sue somebody, either you or they might write a letter that is an offer to settle the matter without going any further. All right? If we do this under what we call the common law rules, they follow the rules in Calderbank and Calderbank. Okay, there are some statutory rules. We'll get to them in a second. But by default, if I am the defendant and I make an offer, and I do it in this format where I've put those words, without prejudice, save as to costs. First of all, me saying, we want to settle for this sum of money. If I sent Ravneet that letter, without prejudice, save as to costs, saying, I want this matter settled now, I'll pay you $400,000 to end this matter now. Okay? The fact that I am admitting or not admitting that there is a dispute is irrelevant. It can't be used as evidence by the other side if you put those words on the top of your offer. Okay? You need to put those words at the top. You need to leave it open for a reasonable length of time, usually 14 days. If you do that, it's really, really important. These are magic words because that says that, look, the other side can't use that letter as evidence in court to try and say, oh, well, you knew you had to pay us because you sent us this letter saying you would pay us $400,000. You can't do that. The only thing it can be used for is the calculation of legal costs later. And so in this example, Ravneet is suing me for $500,000. I've offered to settle now for $400,000. This is a strategic business decision. And that is why I've put this into this subject, and I will examine it too. Because this strategic negotiation, you could say, so to speak, and having these offers to settle going backwards and forwards is essential because the legal costs will change if an offer gets refused. If an offer gets accepted, it's over. You don't have to go to court. You pay the $400,000 you've agreed. It's a contract. You've agreed to pay $400,000. The matter ends. Usually you get your lawyers to write up what I call a deed of release saying, I will no longer sue you for this matter. You will pay me in exchange $400,000. Done. Is it not used as evidence because courts encourage them to give? Yes, absolutely, Henna. That is the reason why they can't use as evidence, because we want people to and encourage people to try and resolve their disputes without going to court. Ravneet, sorry, Ravneet, like I'm picking on you for this one.
So the court order gave me $300,000 just because the defendant made me the offer to settle with these words, right?
No,
Just because.
no, not because no. We've started proceedings, and you were suing me for $500,000. That's the amount you wanted. All right. I've made you an offer at a later time before it goes to court for $400,000. Then you've gone to court, and it turns out your claim wasn't as strong as you thought it was. All right. And so the court has actually said, look, we don't think your claim is worth $500,000. We don't think, for example, the printing machine you've sold me might have actually had defects, and we're argued about it. It's gone to trial. And the amount you've been awarded is $300,000. So you've still won, and by default, because you've won, I have to pay your costs, right? That's the default rule. That's this first one up here, right? The loser pays the winner's costs on the standard basis. That's the lower basis. That's the default rule. But if I made an offer, and I'm the defendant, and then we've carried on to court, and you've still won, I'm still going to have to pay you $300,000. But this gap, the gap between when I offered $400,000, and then we went to trial and you got your order for $300,000. This gap, you have to pay my costs because it wasted everyone's time. Sorry, Ravneet, but that's essentially a policy thing to try and encourage people to make good, reasonable offers that the other side can accept. And that is why when somebody offers to settle to you, if you think you're going to sue them for this much, despite winning, no. Start again. She's suing for $500,000, but she only wins $300,000. Right? She thought she'd get $500,000, but she only got $300,000 in the end. The court disagreed with some bits of evidence or what have you, and she didn't succeed in some of her actions, so she only gets $300,000. She asked for $500,000, only got $300,000. Right? But importantly, me as the defendant, before we went to court, so she fills in the form, pays the filing fee. Before the thing happens, at this point in time, I've said, hey, this is getting pretty real. I'll pay you $400,000 to end this matter. I would only do that if I thought that I was going to lose. And if I thought I was going to lose and have to pay $500,000, it's better for me if we settle now for $400,000, isn't it? Because if I thought I was going to lose and I was going to have to pay $500,000, that offering to settle for lower is good for me. All right? And the courts want to encourage people to settle their disputes out of court. I'm glad that we're spending some time on this. This is good because it's a really, really important practical series of rules, because even though it involves law, it's really a business decision sending these offers.
So you're saying that I'll have to pay you $400,000 less $300,000 plus a legal cost, like the difference.
No. Nope. Start again. You were
I'll
trying
let
to
you
get
know where we
500,000.
got confused.
It's all right.
I just want you to know where we got confused.
Yeah.
The $500,000 we understand, the $300 we understand, the 400 that you offer we understand. You mentioned something about the gap thing.
Yeah, the gap.
Okay.
Yeah, that is something that we don't understand.
The gap is in time, because I'll try and draw it on the screen up the top. That if we've got this point in time here, let's look at my little drawing thing. So this is the start. This is the length of the matter. Bloop, 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 bloop. This is the trial date, and this is the offer. So this is time. T for time. All right. Let's just say at this point in time, Rav sues for $500K. All right. at this point in time, S offers 400 and R rejects offer. The reason why it has to be a rejection, because if it was accepted, the thing ends. You don't carry on the continuum because the matter would end. And then R wins $300, $300,000, $300,000 at trial. Okay, what the courts say is that, look, up until the point in time here, the red bit, I lost. I have to pay Ravnee's costs incurred up until this point, up until the point where I made the offer. Okay? From the point after I made the offer, she'll have to pay my costs. Why? Because all of the costs I've incurred from after the point in time with this offer that she should have taken, all of the costs I've incurred since then have been her fault. And so the courts say, as a result, she should have to pay them. It takes a little bit to get your head around. This is where the defendant in a matter makes an offer. The offer is refused. So just make note, you really want to probably make note of this. It's where the defendant makes an offer. It's refused by the other side, and the other side, the plaintiff, goes on and wins, but doesn't win as much as the offer. So those three things have to happen for this rule, this call-to-bank rule, to kick in. You will still accept, you will still pay. I will still have to pay $300,000. Yes, absolutely. I will still have to pay $300,000, not $400,000. I offered that, got rejected. We know what happens in contract law when you reject an offer. There's no taxi-backsies. Oh, I missed, there was a comment just up there. Sorry about that. Was that Nathan? I didn't see. Oh, Maximilian. Yeah, hi. So what happens when the court's decision is better? Well, if the court's decision was better than the offer, should she have taken my offer? No, not at all. My offer was not reasonable. It wasn't what her rights, it wasn't what she was entitled to. I still have to pay her costs the whole way through. So if I had offered here, and I'll do this in yellow. If at this point in time, if I'd offered to settle for $200,000, and then she went and won $300,000 at trial, in that situation, I'd still be paying all of her costs. So if this was a 200, blah, 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 I'd be paying all of her costs the whole way through. Okay, on the standard basis. All right, that's what happens when the defendant makes an offer and the other side the plaintiff ought to have accepted it. Okay, because they've gone on to win. Now, if she'd gone on to lose the case, so I made the offer for $400,000 and then the judge looks at her case and says, no, you've got no claim at all. So I actually literally win at trial. She has to pay my costs the whole way through because I won. The winner, by default, remember, the loser pays the winner's cost. Pardon me. Okay. Now, and this is the trickier bit here, if we have a situation, the whole cost, the scale cost, it's the scale costs for all of these at common law. We'll get to the statutory rules. They're a little bit different. But at common law, that's the way that does. All right. Now, that is where but you made an offer and then I won. Yes, I made an offer and won. Yes, she ought to have done it. That's right. And in common law, she will have to pay my costs, but by default, it'll be the scale cost. The court actually has discretion for in common law to award it at the higher amount. Okay, they do it in situations where it's unreasonable, but by default, that's going to be standard. Now, it is different, and I'll again draw this up the top. I didn't actually realize that these slides with those white bits at the top are actually quite handy for drawing. So sorry for those that are on the on YouTube. You can't see my little timeline. All right. If, however, all right, so we've still got the same situation here.
They're not missing much, Simon.
Yeah.
They're not missing much on the timeline.
Oh, okay.
I can barely see it.
Oh, really? Oh, no. Okay. Yeah, you can zoom in. The top left-hand corner, there's a little little document with a little magnifying glass on it. You click on that one there. All right. So let's just say that Avnet has gone through and she's again sued for $5,000. All right. But let's just say at this time she offers me to settle for $400. So she makes the offer, not me. She said, "Look, she's suing you $500,000, me $500,000, and I reject it." All right, at that point in time, and then again she goes wins. But let's say this time she wins $500,000 at trial. All right, in that situation, I'm going to have to pay her costs. I'm still the loser. I have to pay costs. But in that situation where she's made an offer for less than the amount that she's suing for, I ought to have taken that. I'm going to be liable to pay her. And again, by default, that'll be the indemnity costs, all of her matters, because I've just wasted everyone's time. Okay, that is across the whole lot. Oops, got my little pen. A whole lot, the indemnity. All right. That
So
is
not the scale cost, but the indemnity cost.
Yeah,
right?
that would be indemnity costs. And again, the court has discretion because these are under the common law, but by default, they will do that at the indemnity amount. Right.
So in the earlier offer, so when I rejected $400,000,
Yep.
I'll only pay for that after I rejected, right?
Yes.
From that,
That's
and
exactly
you'll have
right.
to pay the
Yep.
from 500 to 300.
I will still have to pay up to the point in time where I made the offer. It's to try and encourage me, of course, to settle it early. Because if I'm making an offer, but I leave it till the day before the trial, we've all incurred all of this expense up to that point in time where we could have negotiated and sorted it earlier. That's really how that works. So that's it. So this is the common law rules for doing it. Okay, but so it's a couple of things you need to note: that it's discretionary. So I've put the words here. The judge, the plaintiff can be awarded indemnity costs. All right, and the plaintiff can be ordered to pay defense costs afterwards. The reason for that is that the courts actually do an analysis of for call to bank offers to do with this reasonable length of time and the defendant unreasonably refusing. Okay, and now what you're going to find is that proviso does not exist in the statutory regime that I'm just about to jump through now. So just make note that at common law, the judges still have discretion. If they think that a person's conduct is such that it doesn't deserve this, it won't do it. But that is the default set of rules. So by default, the courts will do that, all right, unless they think that you've acted, one or the other side's acted unreasonably. Okay, so you probably want to just get your head into that. In fact, I'm even going to, I'm going to print screen it. I'll save it into Paint with my little thing there. And the reason for that is it's probably worth you just making a note, going back to the video, checking this this particular thing so you've got a really good handle on it, because it's very likely you're going to get a question that's going to be these. In fact, you'll probably get one of each. We'll say, or you'll have to work out whether it's a whether it is a under the statute, which is the next one, or not. Okay, the formal rules. So when proceedings have started, you can use the statutory mechanism, which is under the Uniform Civil Procedure Rules, which is the UCPR, or the Federal Court Rules. Now again, usually guys, you will be making these decisions, but 99% of the time, if you've got legal representation, they'll be the ones actually drafting the offer and sending it, because there are specific requirements to follow the rules, so much so that it's almost always worth getting someone to do it. They're very short letters. Hey, we want to settle this matter for this amount of money. and you've got 14 days to decide. All right, so just make note that the Calder Bank offers on the previous slide, the common law rules, you can use those rules, and you ought to use those rules. But to do things under the UCPR, or which is in the Queensland courts, or the federal court rules in the federal courts, you've got to follow. I think you've actually got to serve. I think you actually have to serve the documents on them. So you've got to be in a certain form. You've got to serve the thing on. You've got to say it's made under the rules. You've got to give them 14 days after the date that the thing's been served before you act on it. Okay, but really, really important, they're not discretionary. So offers that are made under the rules are not discretionary. The judge must follow them. Okay? So the rules actually play out quite similarly to the Calder Bank rules. Just make note. All right. Going back to this making an offer and winning more at a trial. All right. If the plaintiff makes an offer, that was the one that we'd had on the previous slide on the right-hand side. And if Ravneet makes an offer and then wins more than the offer, I must pay, me as the defendant must pay costs, and it must be on the indemnity basis. The court doesn't get to choose. At common law, they get discretion to award indemnity, but by default, they'll usually do scale costs or standard costs. All right. That was the drawing that I'd had on the right-hand side. That was when Ravneet was suing for this much, made an offer to settle for this much, and then which I rejected, and then she's earned this much. I have to pay her costs on the indemnity basis for the whole lot. All right, so that's the first thing you need to know. That's if the plaintiff makes an offer and it's rejected. These offer things only matter if the things are rejected. Why? Because if they're accepted, the matter ends. You don't have to look at what things went to trial because there's no trial. Okay? Now, this part of the defendant making an offer is different, and unfortunately, not only is it different from the common law, it's actually different in the two court systems. Okay? So, if you are the defendant, so again, Ravneet is here, she is suing me for $500,000. All right, and there is an offer. The defendant makes an offer. Me, in this case, I make an offer for say $400,000 again. 400, 400, bloop. All right, and that's rejected. Then the matter goes to trial, and she wins 300. 100, bloop. Oh, wow, it's terrible. It's so hard to do with a mouse. All right, so the same situation that we had before. The difference being that, again, up to the point of time of the offer, I'll have to pay her costs because I lost. I still lost. I still had to pay her the 300 grand. I've still got to pay her this, and I'm still going to have to pay her costs up to the point in time where I made the offer that was rejected. All right, but after that point in time, all right, after that day, the day that offer was served, she has to pay my costs. And in Queensland, under the UCPR, it's the standard basis, but under the federal court, it's going to be the indemnity, the higher basis of those two things. All right, so you have to just note those two things there, because look, these are strategic things that you guys in business may end up having to go through and do. And so I do think that it is worthwhile you guys just making sure that you know these things, because you don't need to know, strictly speaking, the ins and outs. It's nice to know a little bit about the law, but this is not really the purpose of this subject. The subject is to know strategically how you can use the law. And it's much better to know these rules, because often, if you guys are going to be in strategic management or management accounting roles, you may be making the decision, looking at the risk profile, looking at the offers, and making the decision whether to say yay or nay in terms of issuing offers and accepting and receiving them. So it's worth knowing these things and leaving the stuff in the back of your mind. I think it's a very, very useful set of rules to know. Okay. Now, I'm not going to have a break. We're going to go through to the end, I think. We've got only a few more slides, but it's still a little bit heavy because there are some more things that you really need to know as well. this is a super important one for lawyers, and you guys are going to have to be aware of it. It's to do with time limits. I've alluded to these earlier in the subject, but I'm going to reiterate this because, again, it's the sort of thing it's a good sort of assessment item, because you get the right to sue in contract law when there is a breach of contract. Okay, this is super important because, particularly for you guys are going to be accountants, so some of you breach a contract, by the way, if you give negligent advice, right? That's a point in time. That is the point in time they can sue you. However, the point in time you sue in the tort of negligence is from when the harm occurs. And so this happened to me twice, actually, in my limited legal practice, where somebody gave bad financial advice and wanted to bring was given bad financial advice by a financial planner. And the advice was given more than 6 years ago, but the harm, the business going broke, happened less than 6 years ago. What did that mean? It meant that she could sue in tort but not in contract. Okay, so that's an important thing to note. You have 6 years before you bring it to bring an action in contract or in tort, but it's when you get the right to sue. And you probably need to tuck that one in the back of your mind. Oh, there's a message. Slide 6 says for both. Slides say 6 for both. Yeah, you do. Yeah, it's from when the right to sue arises. What I'm saying is that
Simon, you mentioned in contract.
Yep.
It's 6 years.
Yep.
I must have mixed it.
It is 6 years.
It's 3 years, right?
No. We'll come back to that. Tort, with the exception of the two that I've listed there, which is defamation and torts involving, or actually any action, can be contract or any action involving personal injury. Okay, they have different rules. Okay, but the key thing to note is that the breach of contract is when you get the right to sue. Remember, in contract, you get the right to sue when the other side is in breach. You know, you can always get nominal damages, might get a $10 or $100 and told to go away, but you still get the right to sue at that point in time. But that might not be when the harm occurs. That might come later. All right. Whereas in tort, them falling below the standard, remember that torts, the 3 elements, having the duty of care, and then that duty of care entails a certain standard. And if they fall below that standard, all right, that's the breach. And if harm comes to you as the plaintiff from them falling below that standard, when the harm happens, that's where you get the right to sue. No, criminal law, there's no statute of limitations in criminal, not in Queensland. There are in some jurisdictions, but not here. No, you can be charged for criminal matters forever and a day. You can't be charged twice, though. So if you're charged for a matter and then acquitted, you can't be charged for the same matter twice. That's the double jeopardy rules. But no, there's no time limit. You kill somebody, you can't go to Brazil for 40 years and then come back. Sadly, that is in the criminal. That's in the Queensland Criminal Code, by the way, for criminal matters. It's not the same with all forms of offences. For example, tax matters. The ATO's only got 4 years. Yeah, to go through and bring matters. Okay, so just make notes. Not the same for all things, but for the big bag crimes in the Queensland Criminal Code, they don't have time limits on them. You can bring them wherever. But the tax office, look, if you're doing something criminal in regards to tax, they can bring offences against you, but they can't reassess your taxes. That's really the key thing there, unless they prove a much higher thing, like is it essentially standard criminal fraud. Okay, so that is the default thing. So you must make note that the action, the 6-year clock starts the moment you get the right to sue. That is when you could prove all of the elements of the particular tort, or the breach of contract, or the misrepresentation, or estoppel. And so just make note that sometimes, they said they can be different. Again, the tort of negligence is different from the breach of contract, from somebody giving you bad advice. Okay, so that's just can be an interesting point. Make note that if you have anything, be it contract or tort, that involves personal injury, that has to be done within 3 years. All right, you have to go. I think you actually have to go and get assessed within 1 year as well. You have to go and check those things. Defamation must be 1 year of publication of the particular matter, the defamatory matter. But the default rule for everything else, there are a few obscure ones. Not worried about those. Those are the ones you'll need to know. You're probably going to get some sort of scenario where you're going to have to work out whether they're in time for certain causes of action. Because you guys should know, I mean, you do know that all of the different torts that we had, particularly the tort of negligence and contract, breach of contract, and a couple of other causes of actions, estoppel, unconscionable conduct, and breaches of the Australian consumer law. All of these things, 6 years. All right, from when the bare right to sue arises, and that's the point in time where you could prove all of the elements of it. Can you explain the harm and right to sue in legal advice? Oh, sure. When somebody gives you legal advice, or it's really, I'm thinking more in terms of financial planning advice, right? And the reason for that is that if you're given advice, professional advice, all right, and the advice is bad, all right, now if the advice is bad, in theory, you get the right to sue at the time the advice is done. The advice was bad, right? The person fell below the standard that you paid for as part of doing the advice, but you might not find out until later the advice was bad, after you've taken the advice, and then the advice that was given has made your business go phew. Okay, so maybe, for example, you take some advice to invest in some real estate. All right, take some advice, professional planning advice to invest in real estate, and 3 years later, all of that real estate, all of those houses had termites, and they've all lost 50% of their value. Okay, the person was in breach when they gave you the advice for contract. But in tort, remember, tort has the 3 elements: the tort of negligence, duty, breach, and harm. The harm element you couldn't satisfy until the houses lost the value. Okay, so that's the point in time where you can sue for that cause of action. So even though the advice, you could sue in multiple actions, almost always you want to sue in contract, remember? Because contract by default doesn't have, other than certain statutory modifications, doesn't have contributory negligence as part of it. It's usually easier because in contract, if you can just prove breach, proven causation is easier. It's only got a but-for test with a common sense proviso, whereas it's trickier to prove causation in a tort, and you have to prove things weren't reasonably foreseeable. It's harder to prove the tort of negligence than it is to prove breach of contract. All right, so just make note, you want to be suing in contract in most situations, but the time limits might be different between them, because it's when you get the right to sue that clock, that 6-year clock happens, right? And after 6 years, look, you can try to bring an action. You have to seek leave of the court, but they very, very rarely grant it. You have to have some overwhelmingly strong reason. Ina.
Simon, the point that is confusing me is the first one, in which you're saying that action in contract and tort can be needs to be within 6 years, right?
Yes.
But then you're mentioning that there are 4 things in the tort in which we need to do it in 3 years, right?
Whoa. No. The 3
That's
years
what
thing.
I'm
3 years.
confused.
Sorry, the 3 years here on the screen. You mean the personal injury bit, or what do you mean?
Apart from the injury, you mentioned 4.
Sure. All right. So that was an example. I probably should have picked a different amount. Let's just say, I've given you advice, financial advice, right? And you've made some investments, okay? And for whatever reason, 2 years go by and we don't really check the investment, but it turns out the investments were very bad, all right? But we don't notice until after 2 years, where the person you've done the investment disappears and you lose all of the money, all right? For whatever reason. But for whatever reason, you don't take action for another 4 years, all right? And this can happen if people don't check their investments. It really does happen. Okay. So after 6 years from when the advice was given, all right, appreciate that to sue in contract, the bad advice was given here, was given at the start. So you have 6 years from that point in time to sue for breach of contract. But we know when people are giving professional advice, they also owe you a duty of care and tort. However, the calculation for duty of care happens when the point of time, the clock, the 6-year limit starts when you get the right to sue. And you don't get the right to sue in tort until you've actually suffered harm. All right? That's the difficulty with these two, with the way time limits work. The tort of negligence, one of the elements is harm. So as a result, you can't sue in negligence until the harm actually happens. So that is, at least in that situation, the 2 years after the advice was given. So if, for example, you're trying to bring an action 7 years after the advice had happened, all right, the 6-year limit for suing a contract is gone. It's over 6 years since the advice was given and the breach happened for contract. However, the harm happened 2 years later, and so that was only 5 years ago. So you can still sue under the tort of negligence in that case. That's the one of the tricky things where you've got actions that you can bring, where there's a variety of actions.
As per the injury, the time starts when you are injured.
Yes.
Then.
Yeah, those things there. That's right. Well, again, the personal injury, again, because it involves personal injury, that has to happen within 3 years. That's a restriction on the 6-year rule. So that if your cause of action for contract or for tort, the personal injury, all right, if something involves personal injury, you must bring it within 3 years. Okay, so so you're going to be, it's going to be tricky to do that if it's a breach of contract and then you got injured 4 years later. That's going to be a difficult thing to go through and do, and you're probably not going to be able to sue under that. But assuming that you got the bare right to sue for something being harmful at the start. Yeah. Okay. I'm going to move on to the next one. All right. Assuming that you've gone to court and you've won. So Ravneet, congratulations, she's gone to court, she's won $500,000. What happens next? Well, assuming that she's got an order from the court, a document, a judgment that says Simon must pay Ravneet $500,000 within a certain period of time. Again, usually the court will specify a time, 14 days, 28 days, it really doesn't matter here, right? The key thing to note is that if I don't pay that sum of money by that time, poor old Ravneet has to go back to court to enforce that judgment. Okay? And the creditor, which is Ravneet in this situation, she can have what's called an enforcement hearing. That is where the court will summon me to court, and I'm in contempt if I don't turn up. Where I have to appear and provide information, how much income I have, how much assets I have, what can be sold. All right. Then, in this hearing, all right, that you have, the person will either arrange to pay the thing or to garnish some income. In other words, to pay a certain amount of money every week or every fortnight or every month. So I'd have to pay Ravneet a certain amount. Again, the court organises this at the time. If I don't turn up, the Ravneet could just ask the court to go through and give her a warrant to basically to rock up to the house. Now, usually she doesn't rock up on her own. You rock up in with either the Queensland Police or sometimes the Federal Police to rock up, seize property, and take it away and sell it. You can also get an order for them to sell real property. So if I had a house in my name, to have that to be sold, or make an order that goes directly to my employer or to my bank to garnish money from bank accounts or to garnish things from wages. We call that a garnishee order. All right. Now, if I don't pay, all right, if I don't pay and it looks like it's going to be too hard, or I'm trying to hide assets, or I'm just generally being difficult, and the amount is more than $5,000, Ravnit can ask the court to make me bankrupt. What does that mean? A bankrupt loses all of their assets. A bankrupt is a person who is deemed at law to no longer be in charge of their own financial and personal affairs. All right, so that instead of the bankrupt holding on to property, most of their property vests in what we call the trustee in bankruptcy. All right, so she does that. She can ask the court to make me bankrupt. It's called a sequestration order. When that happens, all of the property, or most of the property, I should say, there's some exceptions here, is going to no longer be held, be legally owned by me. It's going to go to a person allocated by the court called the trustee in bankruptcy. All right, because we accept that natural people, when everything goes wrong and they owe all of this money, they need to have some reset mechanism. They need to have some way to start again. All right, that's why bankruptcy exists. It's to give people.
For how many years you will stay bankrupt?
I think it's 3. Yeah, it's 3. It's on the next slide, which is the last slide for the subject. Oh, that's exciting, isn't it? Oh, it's exciting. Yeah, so bankruptcy is usually for 3 years, and there's a bunch of things that you can't do, which we'll get to. But just note that there are some things that does not vest to the trustee in bankruptcy. The first thing to note, an important thing for you guys to note as accountants, if a particular person is a trustee of another trust, right? That does not get impacted by bankruptcy. So say, for example, here, for this house, if I'm the trustee of a discretionary family trust, where the house is held on trust for my child, for example, if I became bankrupt, so I have to pay Ravnit, and I said, oh no, I've got no money, very importantly, I will remain the trustee for this house. So I'm a terrible person to sue, Butter Ravnit, sorry about that, because she won't be able to access the house because the house is held in trust for my child. All right, so that's an important thing to note. And that's one of the reasons why, by the way, people have trusts. It's asset protection in case you go bankrupt. I'm not intending on going bankrupt because it creates all sorts of problems for lawyers. All right, so just make note that if you are a trustee, that does not get vested to the trustee in bankruptcy. Okay, if I'm a trustee, for the property that I'm holding in trust, so this house, for example, would not go to Ravnit. Also, necessary household property effects. You won't take a person's, so the trustee in bankruptcy won't take a person's things like cutlery, their toiletries, their things that they need to do to function as a human being. That's probably not going to include things like expensive bits of jewelry and such like, but usually items of personality, the trustee in bankruptcy won't take over. All right, things that are necessary for the household. Okay, also the trustee won't take over items used by the bankrupt in earning income. What are some examples of that? Guys, what are some examples of items? Yeah, perfect, Marie, absolutely perfect. Your tools. If you're a plumber, all right, it would be the silliest thing on earth to make you have to give away all of your tools as part of that process. We want people to be able to start again. We don't want to make it too hard for them to start again. Hard car is an Uber driver, or motor vehicle, provided it's less than $8,000. All right, motor vehicles, even if that is you've got an expensive car and you are using it to derive income, it's a statutory rule. Your motor vehicle, it's an indexed amount, but you can have a motor vehicle, but it must be below a certain amount. Look, $8,000, that's actually from a few years ago. It's probably gone up a little bit. It's probably around the 10 grand mark now. Things, what I've got by personal exertion, I'm not sure what I mean by that one. I have to check what that particular rule is. Sorry. items 3 and 4. Sorry about that. The PowerPoint. It's actually items used by the bankrupt in earning income by personal exertion up to $4,000. So there's that. That's actually a I've done the that 4 should be disappearing. I didn't hit. I must have hit enter as part of this when I was redoing these slides. So just ignore that little that one there. So it's item used by the bankrupt in earning income through personal exertion, and it's got to be up to about $4,000. So that includes tools. Look, at the moment in time, it would include computers, if that you're using that as part of your trade. So me, for example, it would include that. It would include my computers. It would include the wireless router. I derive income from this stuff, so this stuff would stay. Interest in regulated super funds or improved. Oh, I've done it twice. Sorry, guys, I've got this twice on there where I haven't. I've hit enter, so it's it looks so bad. It looks so unprofessional. All right. Superannuation by default doesn't vest with the trustee in bankruptcy. Again, superannuation is there in approved schemes for people to have money for when they retire. We don't really want the bankruptcy regime to interfere with that. Okay, what else is there? Right to damage. Also, if you have an amount of money that's going to come to you for personal injury. In other words, you've been injured or it's been a death of a family member. The first one, again, it goes from this idea that bankruptcy will want people to start again. If they can't start again, that's going to be really, really unfair that they have to give away the money that was used to compensate them for personal injury. And also deaths in family. That's more strategic policy things. It's a really bad look if money that you would receive from the dead family member goes to the trustee in bankruptcy to all your creditors. It's just a bad look. Okay, so those things there. So that's property that's exempt. Again, that's the sort of thing that might come up in an exam question maybe, hopefully with better. Oh, I can't believe I've got those little things. Yeah, Hina.
Simon, it's obvious, but I still want to make sure. Like these rules are only for the property that is in the trustee account, because if my home is not in the like I'm bankrupt,
Yep.
they can take away my property, right?
Yes.
So if I'm taking my property, everything is gone, or they're going to leave these things aside and the property is going to be sold. That's what I'm going to make sure.
Absolutely. Yeah, you're absolutely right. These are the protected things that the trustee in bankruptcy can't take away. So they'll take away your little items of personality, your deodorant bottle and your toothbrush and things like that, cutlery, but again, necessary household property in effect. So things that are necessary, jewelry, it's gone.
So they will take away my property, but they will put these things on the road for me and they'll say this is yours, right?
You will go through, and so usually when these things, you have these sorts of hearings, you go through and you have to list all of your property out. And if they don't believe you, they can send someone. The court can appoint somebody to go and actually audit these things, and you have to list the things that you want to include as being necessary household property and effects, your motor vehicle, your tools of your trade, super fund money, and anything compensation from personal injury and such like. All right. So
if you make everything disappear, what's happened?
Sorry?
If you make everything disappear.
I always love these subjects because the law students, they have these same thoughts when they first start studying law, the first years, and after a few years they realize that, look, you have to assume. Sure, people do it. It's like people, when they receive gifts from friends for personal exertion, they don't declare it to the tax office. You're right. Some things are hard to prove. All right. But by default, this is the way the rules work. And so yeah, you're right. Some things are difficult to do. But sometimes, in the case of Ravneet here, for example, she might have an incentive to wander up to my house and take a photo of everything to make sure that I'm not doing it. Because if I did just go and dispose of everything and didn't give it the trustee in bankruptcy, I'm in contempt, and so I'm going to be liable to go through and have to go and pay these things. And the court in bankruptcy, I haven't got it on a slide. I probably should. It's actually a pretty important rule. The court has the power to void transactions that are made by a bankrupt up to a year, up to the point in time where they become bankrupt and afterwards. So if the bankrupt is giving things to people, all right, the court can just void that transaction, say, that belongs to the trustee in bankruptcy. And it can do it to third parties. If you're doing it to family members, the courts don't care. They'll just go through and void that transaction. The trustee can say, that transaction is void. If necessary, I'll go to the court to enforce it. The stuff is owned by the trustee in bankruptcy, and your family member is holding on to it. So you can sue and detain you if they don't give back your stuff. It's your stuff as the trustee in bankruptcy. And so Ravneet, in this situation, she probably would have ideally appointed somebody friendly to her to be the trustee in bankruptcy, who will go through, sell all of my stuff to give her, as to try and pay the debt to her. That's how that works.
So, the banking transactions in your normal course of earning business, so would that be considered trustee's bankruptcy?
No. Oh, sorry. Remember that a couple of things here. If you've got a business and you're running as a sole trader, all of the assets of that business are owned by you. All of the income is your income. It's you and the business are one and the same as a legal entity. Okay? So if you, and again, you and me, we've got a deal. So I was running this as a business. I bought this machine. You've sued me. I've lost. You've got a judgment debt of $500,000. I've only got $100,000 worth of assets. So you declare me bankrupt because for whatever reason, I'm not paying. Then I'm now bankrupt. All of my assets vest with the trustee in bankruptcy, a person appointed by the court. They now own all of my stuff, other than the things listed here. That's their stuff. They are the legal owners of it. They are vested with this job of taking it, selling it, and then giving you the proceeds. That's their job. Does that kind of make sense? I wish you've forgotten what your original question was. But certainly the business aspect of it is, if it was a separate...
I'm sorry, I was just confusing because it's written here, items used by the bankrupt in earning income.
Yep.
So earning income is kind of employee, and business is sort of different thing, right?
Business is going to be separate, so that there's no scope for you to keep all of your trading stock, for example. So if you've got a business and you're running as a sole trader, and I've got all of this trading stock, I've got all of these assets, I've got this real property. Remember that, because if it's a business run as me as a sole trader, they're all in my name. They're all in my name. They're all capable of being grabbed and put into or given to the trustee in bankruptcy and then sold off to go through and do it. Now, the trustee in bankruptcy also has a duty, by the way, if there is a successful business, to carry on trying to run the business in order to get that money out. So there is a genuine need to do that. And it's different also if, instead of it being a business with me as a sole trader, it was a company that I owned. That would be different again, because that's a separate legal entity. But by default, if I've reached the point in time where I've got a business and you've managed to make me bankrupt because I haven't paid $5,000, I'm doing something wrong here. Which, something must be drastically or dramatically wrong with my business. And so the court, again, everything's going to vest in the trustee in bankruptcy, and that could be really bad. These exceptions are really to do with natural people earning income from personal exertion, so their own labor rather than business income. So yeah, it's not really well set up for business stuff. Okay, we're going to have the last slide. I'm super duper tired. The last slide here is what happens. So when you're bankrupt, you've got 3 years. For 3 years, you have to do this. You've got to give your financial position, explain all your present income streams, give your records to the trustee, attend upon the trustee when required. When the trustee calls you up, you've got to answer. You actually have to go through and answer their questions. They take your passport. Yeah, if you're a bankrupt, you lose your passport. And that's...
If I have double passport?
Sorry?
If I have both passports?
It's funny you should say that. I have to be a little bit mindful because I don't want it to be public information. But I entered into a yeah. I don't know. I don't know whether we could. I actually had this argument with somebody about the family law regime. Does the family court have the power to take away my New Zealand passport? I don't know. I suspect that they do, but I genuinely don't know. I'm going to go and find out. I think that's actually worthwhile. Well, that's a worthwhile question asking because a lot of us have got two passports.
Because it's limiting the freedom of movement of a citizen from another country.
Yes, although if you think about it, how have you as a citizen of another country become bankrupt in Australia? So
it's
that
possible.
Usually, as a citizen, you can have the right to return to your country of domicile. So you do have the right to go through and do that. Again, how are you going to pay for it? That's really that's a you thing. And so that going through the process of making someone bankrupt, people don't do this just for the fun of it. You usually do it to try and get a result. Right?
Yeah,
so
but
in this case, Ravneet would only
just the poor people, the illiterate people, they get bankrupt because the really, really good crimer or frauder,
yeah.
they're with wetsuit and nothing happens.
You're right. And so you've got these rules. You are right in that idea that people that have assets in multiple jurisdictions, it's difficult to obtain that information, particularly when people are recalcitrant. And sometimes people become bankrupt because they've been unlucky. Often people become bankrupt because they've been stupid, or they've taken risks. You guys are accountants. You all appreciate this idea of risk reward. More risk equals more reward. But sometimes more risk means you lose everything. And so that idea of having people that live their lives and heavily gear their investments. So they borrow lots and lots and lots of money to buy real property or shares to do investments. And then there's a downturn and then they lose everything. They still have the same bankruptcy regime as a person who runs over somebody and isn't insured, or for whatever reason causes some harm, drops a cigarette somewhere and burns a house down and doesn't have insurance. All right, that the same rules for bankruptcy apply to both types of person. 3 years, they have to do all of these things, surrender your passport. So for argument's sake, I'm going to assume that that's only the Australian passport, but it said it might be other ones. I'd be surprised. I wouldn't hand over my foreign passport if I don't know why surrender. It's a statutory rule. And so with that, look, Australian courts are going to have the power under the statute to take Australian passports. Whether they have power to take foreign passports, I don't know. The more I think about it, the less I'm convinced that they would be able to do that. All right, but why give it to the trustee? The trustee looks after it. They hold on to it for 3 years. It's part of their role. Can you be bankrupt, fines, or tickets? In order to become bankrupt, you have to have somebody going to court to ask the court to make you bankrupt. So you have to have a sequestration order, and for public policy reasons, government departments you owe money to, Spur being the big one, don't make people bankrupt. For policy reasons, they don't do that. Try to avoid that. Sometimes, and I've advised people in doing community legal, when people end up with fines more than about $20,000, that's the point in time where I say to people, you're better off going bankrupt voluntarily. The thing is with going bankrupt is that a person you owe $5,000 to, and just out of interest, with COVID-19, that amount's actually been increased at the end of the year to $20,000. They don't want people doing this to others in this climate, so they've actually passed a temporary change to this law. So where I've written $5,000 for your exam, you'll need to know $5,000, but just make note it's actually 20 during the pandemic. It's a small change. You don't have to worry about that. If I'm a trustee and I become bankrupt, can I still work as a trustee? Well, remember, a trustee is not work in a trustee. It's a duty. You will have a duty as a trustee, yes. Whether you can get remuneration from it, yeah, probably. But again, you'd have to account for that back to the trustee. Remember, the whole idea of bankruptcy is that for 3 years you account your money to the trustee in bankruptcy. All right, you can't obtain credit without disclosing that to the credit provider. You have to follow their lawful instructions. You have to keep telling where you are, address, daytime telephone number. You can't sell or deal with any property existing at the date of bankruptcy, as all divisible property vests in the trustee. So apart from those exceptions we had in the previous slide, you can't do anything with that property. And you can't be involved in the management of a company. So you can't be a director, and you can't be a CEO or a CFO without leave of the court. So you have to ask the court to do that. Okay. That's bankruptcy. And that is the last topic for this whole subject. Now, in our few minutes left, what's a good day for you guys to have an additional session? I think Monday. I think Monday's the best day for me. And it's, you guys mentioned that you've got something on Sunday night for accounting?
Yeah, accounting.
Okay, I'll take that. I don't know with the will of the majority of the class, but we'll go. I'll send an announcement when I've gone through it. Like I said, it'll probably be during the weekend because I'm hoping I can finish marking. I said I'm probably going to mark the take-home test first, by the way, rather than the assignments afterwards. Largely because the type of answers for the take-home test, the style of answer is going to be similar to the exam. I'm going to make it short. It's going to be short, but you're going to be questions like, Sugpreet is about to sue Hina. Hina makes an offer. I mean, I won't use your actual names, but it's that style of reasoning. So you're going to have to know the rules, and you're going to have to be able to apply them to get to the answer. Don't just give the answer. Do a little bit of reasoning as part of it.
Okay, they will be all the same or different too?
Same or different? Sorry,
they will be the same for everyone, or 10 different?
Oh no, it'll be the same. It'll be the same for everyone at this stage. I'm not going to do multiple. I won't have time.
Simon, a request.
Okay. We will use responder.
No responders.
Okay, perfect.
Hina?
Simon, a request. Please don't put the limit of 200 words. We will not write stories.
No limit. No,
but
no
at
limit.
times it gets so hard to put it. Like in one of the questions, in the end, I felt like leaving the question because I could not put it in 200 words.
Okay.
It was exceeding.
I thought it was actually pretty. I thought it was.
See, it had part F, right?
Yeah.
In 3 parts, my 200 words were up, and I was like, okay, what should I delete? What should I remove? And in the last question, when I managed to squeeze it in 200 words, the limit was 400, and then I had to add more, and I was like, so please don't put the word. We will not write 2,000 words. We will stick to the point, but don't put the limit thing, please.
Yeah, I won't put a limit, but it shouldn't be that long. In terms of,
I mean, my answers were not more than 3 lines, but I still exceeded 200 words. I don't know about the others.
Okay,
I was exceeding the limit.
All right, I'll be.
No, the same happened to me. I had to cut words.
Same happened with you as well.
Yeah, it happened to me. I had to cut, like, it was 500 once, and I had to cut. Oh my God, it's just 100 words.
All right, there won't be a word limit on the exam, but it'll be shorter anyway. So that's that it'll be short. That take-home exam was much longer than the final exam is going to be. Even though it's
because the numbers also. I'm sorry, Hina. The sections when you quote 29 something, and that also counts in the words.
No, it's not. I mean, with those things, look, I the take-home assignment, the word limit. I thought that 200 words was going to be heaps. I thought it would be heaps for them. I said I went and did some sort of model answers, and it was quite a bit shorter than that. So yeah, sorry, I didn't want it to. I didn't want it to be too much work. How long was it? How long was it for you guys? Did you spend more than sort of 3 or 4 hours? Oh no.
Yeah.
Yes.
More or less the time.
Okay. Yeah, heaps more. Okay. All right. Sorry, guys.
I have to be honest, because I
With me, it
didn't know
was
how to imprint. Mine's like 1,400 words, you know.
Oh, sorry. I did not expect that to be 10
Simon,
hours.
I'll
Okay.
give you an example. Right now, we are taking a session from 6 to 9 non-stop. Even if my kids are beating one another, I'm like, okay, that's okay, I'm ignore.
Sure.
But when I'm doing the home tech exam and I'm listening to your point because I want to be clear, I'm getting up again and again and I'm re-listening to it. So it got stretched. It
Okay.
did.
Sure. Sorry to hear that, Maximilian. I didn't think it would be anywhere near that. Is there extra session for revision of content or review potential exam type questions? We will do potential exam type questions. Yes, definitely exam questions. Yes. Hardest was to reduce and work out key point. Okay. Oh, sorry. I said I'd when I'd gone through and doing it, I said I'd just gone through and did a model answer, and it was there wasn't much to it. But so yeah, sorry about that. I genuinely thought that it was going to be come out a little bit short. Other than that last one on fixes and chattels, which gets a bit wordy. We don't know the term marks. You will know the marks from the. I'll definitely have. All right. I will definitely have the take-home stuff done before Monday. You will definitely know the assignment marks. I may not be able to have detailed structured feedback for the assignment. That's the key thing. That's really that. Because I've got a stupid. You may be aware that they're the when we're doing things online. The business online thing is now I'm now supporting 3 colleges. So rather than just business law and governance, it's science and engineering and hopefully not, but it might end up being the arts and social sciences as well. So it's been a tricky semester, and for you guys as well. And of course, we're doing everything from home. It's crazy. So I'm definitely going to go through the exam questions. In fact, they may be very, very similar. We possibly will do questions on Monday. What's a good time on Monday? Is 6 o'clock okay? Checks moved from a system of commerce altogether. Yeah, why would not discuss? This is only for Australia or worldwide. Oh, well, either or is both. It's worth you to have a think about that one. I think checks are just a total waste of time as a private instrument, but they can be valuable when done through banks. So bank checks. Is 6 p.m.? Okay, we'll make that 6 p.m.
Simon, if it's possible, can you make it Tuesday? Because on Sunday we have accounting class, so we'll be getting ready for that.
Okay.
On a Monday, I won't get time to look into questions that I need to ask you.
I think I might. I'm going to try and put it to the majority. What I'm going to do it as a quiz. I'll bring up a little quiz. So we're going to do it, the will of the majority, because all of these things we're always going to have people do this and that. So what I'm going to do, I'm going to go. Okay, so I'm going to do it. Which day? And I'm going to put. So I'm going to make it. It's going to be at 6 p.m. So regardless, is it Sunday, Monday, Tuesday? Tuesday is a little bit complicated because I have my child until so I will have to. What topics will be set? I think it's actually most of the subject, but it's going to be the emphasis is going to be on the final three weeks. It's Monday. Yeah, Monday's going to win. It's the will of the majority. So what we're going to do, I mean, it'll all be re-recorded, so you'll be able to watch and collaborate afterwards, and I'll stream it to YouTube as well. All right, so Monday is a goer. Monday, 6 p.m. Well, it's going to be a goer. I'm going to put it in a little announcement. I'll do a little announcement, and we're going to make that a thing. So I'll have to bring my business online up. All right, so I'm going to leave this session here, but I will be joining you again on Monday. I'll send an announcement and tell you how we get on with the assignments there as well. I will still ask questions. Yes, carry on with questions. Oh, you still ask questions. Yeah, nice. But I'm going to disappear now. I'm going to call up to find out where my dinner is. So I'll see you guys. Thank you so much. We're going to see you again on Monday. So we'll be in touch soon. But yeah, that's the content. Like, yay, it's all done. Good luck, team. And I'll turn the recording off. And I will talk to you soon.